And this morning I am told that they have come and they have moved for an adjournment and it is posted to 17-1. My lord, we just wanted to make a submission with regard to the IA in 50.4. And we had already informed the petitioner's counsel, Mr. M.M. Swamy. But now I'm informed that they had submitted to my lord that the matter is pending in the Supreme Court, so a date may be fixed.
Date is already.
Yes, my lord. Last time we had made a submission that we wanted my lords to consider.
Date is given 22nd of January.
My lord, we had got it posted specifically for today, only to consider IA 1 of 24, my lord, for direction.
Or about?
My lord, this is with regard to quarrying of an area, my lord, where their permission was granted for gold. But there we found that there are iron deposits. So we just wanted an order with regard to, my lord, the iron ore. The Additional Advocate General, Mr. Rubin, will be coming only for the limited purpose of that. And if my lord feels that, my lord, an order cannot be granted, then my lord may have it for 17th. I have no objection.
It is kept on 21st, 22nd.
Of January.
You want this side?
My lord, if it could just be passed over, my learned friend is also there.
Then 16th.
Very well, 16th.
16th.
Obliged, my lord. I'm sorry, my lord, I embarrassment.
But you take a note, 16th it is kept.
16.
You are for appellant.
I am for the.
So 16, 12.
28 provision has been
16, 12. Right?
With your lordship permission, Lord, serial number 11, we are permitted to withdraw them, Lord. I'm told that, Lord, the order is complied.
11.
11, Lord.
So Silva 11. 1, 2, 4, 3, 2, 4. Learned Mr. You are Mohantesh.
Please, Lord.
Mohantesh S. Osmat. Files memo. Handwritten memo dated 4/12/24. In which it is stated that since the order under contempt is complied with, it is complied with,
It's complied, Lord.
in which it is stated, in which request is made to permit the withdrawal of the present petition, as the order under contempt is complied with by the respondents. The memo is taken on record, dismissed as withdrawn.
My lord, one submission, my lord, memo for posting, my lord, kindly have it on next week, my lord, because my lord, there is an urgency in this matter, my lord. The petition has grown in paddy in their land, my lord, but the respondent is not allowed to cut the paddies, my lord, that's why.
What is the urgency?
Please.
What is the urgency?
Urgency is that, my lord, the petition is in possession of the land, my lord. It's a paddy in that land. The petitioner intended to cut that. That grown.
It is a contempt
No, my lord. It's a RP review petitions, my lord.
review petition.
Please.
What is the date of the order?
Next week, any date, ma'am.
What is the date of the order under review?
My lord, now we are filing an impleading applications. The same is pending, my lord. It's not consideration. In the meanwhile, already in the review petition, there is an interim order granted by this honor. Please. The impleading applicants are the unauthorized occupants.
Eleven.
Please, much of it.
Not before. Madam, it is not before this bench. It is before which bench? Oh. Just it takes you. You forward this memo to register judicial. We'll do something.
Please, madam.
Any mention through VC, sir? List number 1, contempt matters. Seal number 1, Mr. R.G. Hegde. Seal number 1, Mr. R.G. Hegde.
Keep that.
Seal number 2, Mr. Madan Gowda.
Appear for complaint in this case, Your Lordship. Lord, the complainant was working as a Hindi teacher in Moraji Desai residential schools, Your Lordship. May I audible, Your Lordship?
You relieved.
I have been relieved, Your Lordship. In
You're
spite of
relieved?
order. Yes, please, my Lord. Please, my Lord.
Notice returnable on.
No specific order has been issued for relieving me, my Lord, but by oral admissions, my Lord, they have relieved me, Your Lordship.
January 8.
A specific action so far as since my Lord, I don't have any source of income, Your Lordship. Since they have relieved, my Lord, as last 3 months, my Lord, I am without any source
You
of income, my Lord.
Issued notice January 8.
Please.
Seal number 3,
Lords,
Amadevi Remat.
I appeal for the petitioner, my lords. My lords, the order, relevant portion of the order of the learned single judge is at page number 18, my lords, wherein there is a specific direction to all the authorities to take necessary, pass necessary order promoting the petitioner as
Notice
assistant.
returnable on 20th January.
Obliged, my lords.
Number 4, Mr. Jagdish DC.
Appearing for complaint. But complaint was working in government.
There is no time limit prescribed by the law on a single judge. Page 55, the order.
Yes, my lord. Order of the learned single judge. 55-56. But the complainant was working in the government tool room and training center. It's a fully aided and government institution.
But-
State of Karnataka enhanced the retirement age of government employees from 58 to 60 years. And it was made applicable, government order was made applicable to the employees working in local bodies and also aided education institutions.
An order
What are
passed
the-
on 6th.
Which
September.
direction, Mr.? Which direction you want to comply with?
Accused number 1.
Read. Which direction you want to comply with?
The complaint, the order of the learned single judge, but that is in page 55, madam. 55.
Read it.
Though petitioner would succeed by virtue of a division bench judgment of his court.
Don't read entire order. Which is the direction? Which is
That's
the
it.
specific direction you want to comply with?
Yes, so that is in page number 55.
Read it.
Though the petitioner would succeed by virtue of a division bench judgment of this court, but however, in view of the pendency of an appeal against the judgment of the division bench of this court, the petitioner being entitled to the benefit of retirement at 60 would depend on the result of the said appeal. In the meanwhile, however, the petitioner shall receive the terminal benefits due to him on the basis of that he has attained the age of superannuation at 58 years without prejudice to his future claim. In the event that the appeal pending before the Supreme Court should be decided in favor of the similarly placed petitioners, and in which event the present petitioner also shall enter to such relief benefit if the pending appeal should succeed. With these observations, the present petition stand disposed of. This is the order.
What direction?
May I make the facts of this case?
What is to be complied with? You
Yeah.
tell us.
Notice to be compliance of the learned single judge passed.
What are the direction?
But they have, he was retired from service on attaining the age of 58 years. He is entitled to continue till the age of 60 years as per the government order. He was lived in attaining the age of 58 years.
Appearing for response, file my response. to
That's
that,
this order is of 2011 minutes. 2011 order.
Matter was pending before the Supreme Court. Supreme Court has passed a dismissed a civil appeal filed with accused number 1. But that is dismissed in on 8/11/2023.
Which is the order which is confirmed by the Supreme Court?
The annexed order passed by the division benches of Sample Court.
That is it.
Annexed B, my lord. Annexed B.
Same order is confirmed.
Yes, confirmed by the Supreme Court. I have produced Annexed D is the order. Civil appeal number 8070 came to be dismissed. It is held that the learned single judge of the court and also divisions of the sample that the government tool room training center is also an aided educational institution. It's fully funded by the state government. So employees of this institution are entitled to continue till the age of 60 years. But the first accused, he has not bothered to give benefit to the government, as per the government order. He had to allow the employees to work till attaining age of 60 years.
You are for whom?
I am for respondent number 1, my lords, the managing director of GTTC.
So you will be the reinstating authority.
I'll take instructions and file a response, my lords.
What report?
My lords, the sum and substance of this case.
Confirmed by up to Supreme Court.
Please, my lords. The sum and substance of the case was, my lords, one Yogarajan, there was this circular issued by a government, my lords, saying that from 58 years to 60 years, superannuation was increased, my lords. The age of superannuation has increased. But GTTC did not fall under the ambit of educational institutions, so they did not heed to that particular thing. So that particular circular order was challenged before this honorable court by one Mr. Yogarajan. This honorable court held that GTTC is an educational institution, and that particular order was also challenged by the Supreme Court. Supreme Court did not venture into the merits of the case insofar as whether it is an educational institution or not, and allowed the appeal insofar as civil appeal insofar as Mr. Yogarajan specifically is concerned, and said that he is entitled because we will not interfere with the
No scope of
Not allowed
argument.
dismissed.
please interfere. Now I will.
There is no scope of argument.
Arguments.
Supreme Court is confirmed.
Please, my lords. Now I'll file my response, my lords. 2 weeks
Okay.
time. Will be granted.
Now it is-
That's all. They're
Civil appeal
taking
came
some
to
steps.
dismiss. Civil appeal came to be dismissed.
I file heard learned advocate so and so for the petitioner, learned additional government advocate Sramodi Nikishan for the respondent state, and learned advocate Mr.
Achappa, my lords.
Achappa for respondent number 1.
Yes, my lords.
Also, the present contempt petition seeks to enforce order dated 6th September 2011. Passed by learned single judge in the writ petition number 15382 of 2009. Course of the order reads as under. Report the entire order. Full stop. The
5, 6, 7 also similar cases.
notice in the background,
Okay.
the division bench while discussing the earlier writ petition number 1786 of 2009 in the same subject matter, directed the appellant before it, dash the government tool room and training center, dash the respondent here, respondent number 1 here, to reinstate to reinstate the petitioner respondent into service within 15 days and to continue him in service till he attains the age of superannuation at 60 years. All benefits accruing to the respondent petitioner herein was directed to be paid. Paragraph. The aforesaid order passed by the division bench was carried before the Supreme Court by filing civil appeal number 8070 of 2020, which appeal came to be dismissed by the Honorable Supreme Court as per order dated 8th November 2023. It is thereafter that paragraph present contempt petition is filed, seeking the compliance. Full stop. A bare reading of order dated 6th September 2011. In the order of this, read 6/9/2011. Would go to show that any time limit is not prescribed for the purpose of compliance. However, in the original order passed by the division bench, which was confirmed by the Supreme Court, 15 days was given for compliance by the court. Full stop in the aforesaid view. And not in the aforesaid view.
That 15
Although-
days was only for
therefore,
reinstation.
No time limits prescribed in the order under contempt in the present proceedings. In the aforesaid view and the first order of the division bench provided time limit for compliance of the directions regarding reinstatement, and that the same has been confirmed by the Supreme Court, compliance has to be effected by the respondents. Therefore, by providing that the order shall be complied with within the period of 4 weeks. 6 weeks from today, the present contempt proceedings are closed at this stage with an observation that if the order is not complied with, the respondent shall be exposed to
Instead of 6 weeks, 8 weeks, my lords.
aggravated form of contempt.
8 weeks time may be granted, my lords, instead of 6 weeks.
Reinstatement, 6.
No, my lords, in this case, there is no reinstatement, my lords. The issue is this, my lords. One Yogendra,
We are entitled for retrieve
they have-
benefits.
they have retired, my lords. There is no reinstatement in this case. This is only regarding.
Penal benefits.
Benefits.
We are entitled for
That's all, my lords.
benefits.
That's all. There is no.
Benefits till the age of 60 years, whatever the size,
You
we are entitled.
You attain the age of 60 years.
He attained the age of 58, at which point in time the court, in the order dated which your lordship.
So today, there is no question of reinstatement.
No
No,
reinstatement.
no, sir.
So the 6.
They are entitled for only
8
benefits. From
As the
58 to 60
compliance-
years.
as the
Whatever the
part
salary
of
they
the
were drawing.
compliance which remains is to pay the resultant benefits, consequential benefits.
Retirement benefits from 58 to 60 years, whatever the
Council
benefit they are
benefits.
entitled.
Counting the age of retirement up to 60 years. And that the petitioner has already reached the age of.
Yes.
8.
Please. Same order in all the cases,
Hmm?
madam. Same order in all the.
No, my lords, insofar as the other cases, notice has not been issued, we do not know if they had participated in the writ proceedings, if there is an order specific in that particular, this
But
thing.
same order,
Ah,
where is
My
the
my
question?
lords, the accrual of the same
applicable
benefit
to-
might not be available. to them.
Same order, where is the question of?
People are applicable to person,
My lords,
other complaints.
In these cases, the petitioner had approached this honorable court, my lords, specifically, and they were given that benefit, my lords. In the other cases, I don't think they have approached this honorable
Ah.
court or any court seeking for that benefit, my lords. Insofar as the GTTC being an educational institution, that particular point is left open by the honorable Supreme Court, my lords.
Lord, other
I will
applicant-
just
they
read
are-
that
they have
particular
also-
portion,
they
my
Also
lords.
approach the summary court.
I'm not sure. I do not know, my lords. I do not have the
Leonard Friend has not made note of. In all these
page 58, my lords.
Approach,
Similar, same order.
yes,
If maybe in different, but same order by the division bench.
yes, I have produced out of the. Leonard
Have they approached
Same,
this?
same number, same petition.
My lords,
Friend.
I'm not aware of that petition, my lords.
All I noticed
Let me
written
have the benefit of.
13th of December. You saw learned counsel for
For the first time matter has come up,
once.
I bet my Leonard Friend has not seen.
Permit us to pass. The
Please.
learned advocate for the petition submits that this petition is identical to CCC number 1140/24, which is disposed of today. However, since notice is not issued, let there be notice returnable on 13th of December. First of learned advocate, the petition shall give evidence copy to learned counsel, Mr. So and so, as well as learned AGP, who shall appear on the next date to assist the court, please. So same order in 5 and 6.
The previous matter, my lords, there is some office objection regarding the wakalat. I think some other office I had signed. I be permitted to file a better copy.
Once one matter is disposed of identity.
Please, my
Go
lord,
back,
in
take
that, in that the wakalat needs to be rectified, my lords. I'll file a better wakalat.
File what
Right,
you want.
in the other cases, my lord, they were also employees working. They were asked to retire from service. They filed writ petition in Supreme Court. The Supreme Court said that since a matter is pending before the Supreme Court, wait for till that. Now Supreme Court has dismissed the
On 13th,
same order applicable to all the cases also.
come on 13th
I will give copy.
and give copy to.
Please.
The learned friend, yes.
6, 7 also.
7. Bill number 8.
Mr. Amit Nayak.
As I'm appearing on behalf of the complainant's counsel. Lords, there was an order by the division bench of this court, my lords, in 13774 of 2020. The PIL, my lords, a specific direction was passed. Your lordships comes to page 15. In page 15, the specific direction is found, my lords, paragraph 5. As regards prayer B, it is the duty of the state government to ensure that if liquor is being illegally sold on a complaint received on that behalf, immediate action is taken for preventing illegal sale of liquor. If an organization of women makes such a complaint, it is all the more necessary for the state government and its officers to act very expeditiously considering the rights of women. Hence, the state government shall take action accordingly. My lords, following that, there is an Andolan called Madhya Nishedana Andolan, which was the original petitioner also. My lords, one of the members of that Andolana filed the original PIL also. Several thousands of complaints have been given, my lords. Action has been taken in 1 or 2. That way, I also produced that action.
Where is prayer B?
My lords, prayer B, my lords. At page, if your lordships look at page 14.
Page 14.
Page 14, the Honorable Court set out all the prayers. Prayer B is issue a writ in the nature of mandamus or direction to immediately stop sales of liquor through illegal shops or houses in the entire state. So the court clearly directed if there are complaints filed by women particularly, what's happening, my lords, is illegal liquor is being sold through tea shops, grocery shops in villages, not licensed shops. This is only against illegal sale. Women, my lords, have been sitting on dharna even to seek enforcement of the High Court's order. So as a final resort, we are approaching this court.
Heard learned senior of Mr. So-and-so, so-and-so. One of the prayer in the writ petition, which was declared by learned single judge, as per order dated 1st December 2020, was to direct the respondents to stop the sale of the liquor through illegal and unlicensed shops of the houses in the entire state. Full stop. In paragraph 4 of paragraph 5 of the order, which I of the order, it was provided by a single judge that as regards said prayer in duplicate small b, it is the duty of the state government to ensure that if the liquor is being illegally sold, from on a complaint received on their behalf, from immediate action is taken for preventing illegal sale of the liquor. Full stop. It was further observed that if the organization of women is the complainant, the duty of the respondent is even greater. It is in respect of the above direction that the complaint is alleged. As the complainant has put forward a case that no action is taken. So, direction of observation was made in paragraph 5, as above, by a single judge. Notice returnable on 9th of January.
Much obliged.
Bill number 9.
9th is okay.
Okay.
And
This is a civil contempt matter. Non-compliance of the honorable single judge order matter.
9th
Yes.
notice returnable on.
Emergent notice.
17th Jan.
Others are state matter. Only second respondent is
All notice will go to all.
Bill number 10. Mr. Vasant Kumar HD.
Who appears? Who appears? Keep back.
Vasant Kumar.
10 keep back, yes. 11 is
Then
already,
adjourned. Seal number 12.
yes.
Mr. Somshekhar RP.
12.
That for
Who
violation-
appears here? Similar matter was disposed of.
Lots,
You just check it.
I'll take. But here in this case, there is no time
Only
specified.
Miss Akbar appeared. This is that raid, police raid matter.
Yes, madam. Police raid, madam.
Miss Kisan, you find out there is some order, identical order, some order is passed, either dismissal or some clarification, some order.
Right.
Thereafter will take up. Keeping on 17th of
Please,
December.
please.
You must be knowing, mister.
Please, madam.
You must have appeared earlier in the similar matter.
Yes, my lord. Similar matter I have appeared.
Huh? Similar matter.
Not my lord. Earlier I also filed a different petition. That in that case, my lord, they have
But
filed
sim-
affidavit and closed the case. madam.
But similar order.
Not similar order, but
Lie. That is what we are telling.
that I will produce, my lord. There, my lord, they have filed affidavit. Therefore, my lord, the matter was closed, my lord. Here, my lord, in this case, my lord, they have
Produce.
occupied the premises and taken away CCTV, DVR, accounts book, cash books, library books, everything, my lord. Now it is under the lock, my lord.
Also find out the.
I'll take instruction.
This PIL matters. Seal number 13. Mr. Srinivas Murthy.
I appear for the petitioner, Mira. I have sought for a mandamus to the fourth respondent that he is the sanctioning authority for the approval of the plans. Layout has been approved, leaving the margin for northern side is 20 feet. But the authorities for issuing the plan, they are encouraging the illegal constructions. It will be difficult for the agriculturists to carry out the agriculture inputs to the sandy day.
Read your prayer, maintain the respondent, directing the respondent to maintain the road
with 20
width of
feet road
20
and
feet
north
of north
road.
and south.
As per the sanction plan at
For the
Annexure C,
respondent.
in the event of approaching sanction of plan by the dweller to
What is
put
that
up
in
the house,
That last part, in the event of approaching for junction plan, by any dweller to put up house, what is it?
because the layout plan has been approved, it's a private layout. 20 feet road has been earmarked as per the approved plan at Annexure C, Miller. Now the authorities who are issuing the sanction of the plan, they are never looking into the structures and they have encroached the property, including the road margin.
Who has encroached?
Some dwellers.
Which respondent?
I'm a general public.
My lord, one of them is respondent number 5, who has encroached to an extent of 7 to 8 feet on a 20 feet road, with the result that the width of the road has reduced. Now, it's the town municipal corporation, my lord, who has to take action. Respondents 3 and 4. And they are, respondent number 3 is represented by Mr. Ramesh Kumar.
The only request is the encroachment should be clear and the road margin should be left as per the approved plan. In the event of sanctioning any approved plans to anybody who approaches the authorities.
My lord, my lord, my lord, may please lordship, I am in item number 14, my lord.
Sir,
Am I
13 is
audible, my
called out,
lord?
sir.
Yes, my.
13 is running, sir. Till number 13.
Okay, next, sorry.
My lord, but the lady who has really encroached is not made a party in the petition. Very well.
He is the person who has formed the layout. Para number 2, Miller, para number 2 of the petition. Para number 2 of the petitioner, the petitioner being general public not having any personal interest. No, Miller, I am not interested. I'm not interested. I never said. I will look into it, Miller. Please pass out.
No, I don't have that copy, my lord. Okay.
I buy for weeks time to rectify it. No, Miller. It's only I sought for your aid. No, I have never stated that I am running a trust. I never stated, Miller. I mean, this first pair, I have never made it because we were 14:1 already.
Because
Okay, this is my read petition.
otherwise I would have attached that.
This is different, that is different. Liberty may be given to file fresh petition because that
Cell number 14, Mr. Hussain.
May please lordships, I am for the petitioner in this. My lord, I am for the petitioner in this PIL writ petition. On the previous occasion, your lordship has pointed out that the legal attorneys I have, and I am producing some documents, my colleague is there. A very serious issue involved in this public interest litigation, my lord. Because all the digital platforms are showing this, which is affecting this. The lordships were convinced on that day that we are issuing notice, but
Yes, my lord. So we were supposed to make a filing today. That we have done today, my lord. I am for the petitioner, my lord. My senior is available now.
my lord, my colleague is filing this document to satisfy the locus standi to file this public interest litigation, my lord. Anybody can file this PIL, but there is the law of.
No, in fact, my lord, as per the writ petition para 22, not para 22 of the writ petition. Para 22, page 19. The petitioner says, in July 2015, the Supreme Court of India refused to allow the blocking of pornographic websites and said that watching pornography indoors is in the privacy of one's own home was not a crime. So according to him, the issue is settled. And in the next paragraph, he says, the Ministry of, our Ministry, Electronics and Telecommunication, has banned 857 pornography sites and lifted the ban again and has asked ISPs to ban only such website where there is child pornography. So I do not understand what remains.
In spite of all these things, this is shown by all these digital platforms, my lord, as a very serious issue to be taken note of.
And very vague prayer, my lord. It says the prayer number 1 at page 26. It says,
gone respondent number 1 and 2 to make a ban of such above mentioned. He has not mentioned any websites at all. And in bracket, he gives some 3 names. This is not how a PL. I mean, he should give and Honorable Supreme Court has said we can't ban.
The parties before the court, my lord, in the petition.
I don't have the order, my lord.
That's why I'm seeking.
I'll furnish. Lordship may call it after vacation, my lord.
Supreme
I'll
Court
get some
matter is
instruction.
pending.
My lord, we have filed it today, my lord. The document stating the locus standi. Time because senior was not available, my lord.
So, my colleague may be permitted to file the same during the course of day, my lord.
This is number 15 to B. Vishweshwaraya.
Obliged, my lord.
Yes, so we have just come on record. Please give us some time, my lord. We'll take instruction.
One submission, my lord. Till then, collecting breast milk and selling breast milk may be stayed, my lord. Because March means there are another 3, 2, 3. No, they are collecting from the poor rural women, my lord. That is the difficulty. At least a oral direction. Much. It is a human error, my lord. By that time, I was not keeping well also. The junior colleagues of mine office made a mistake. No, till date, I'm taking treatment for I will apologize to the court, my lord, regarding match. No, in future, I won't do it, my lord. Match.
This is number 16 to Sagar V. Shastri.
Please, your lordship. Lord, petitioners are the devotees of Sri Lakshmi Narasimha temple, my lord, which is a Mujarai temple. my lord, the LRs of former Archaka have, my lord, the illegally transferred the, my lord, the temple property in favor of respondent number 10. Which is contrary to the decision of the Honorable Court, my lord, in state of Madhya Pradesh versus Uttam Awam Kalyan. Originally, this property belonged to the temple policeman. We are the devotees of the temple. Now temple is locked. There is, because of this, my lord, the dispute. Earlier, my lord, land was standing in the name. It was given to the, my lord, to the temple. Later on, my lord, the Archaka got his name entered. Now he is no more. His LRs, my lord, illegally transfer, my lord, this land in favor of respondent number 10. Original Karda documents, my lord, stands in the name of the temple, survey number 36. The Archak has no right to, my lord, to transfer. Now he is no more. His LRs have illegally transferred. As per the decision of the Honorable Court, Supreme Court, my lord, property has to remain in the name of the temple or deity. Now, in the name of private persons, my lord, it is standing. We have produced the Supreme Court judgment, Honorable Supreme Court judgment at page 301. There are 2319. And the land has not been granted to in his favor by any authority. Merely by taking, my lord, some fictitious entries, land is transferred.
My lord, the prayer may be seen. My lord, this is a tribal issue. They have to go before the trial court. Once that is decided, my lord, then the release with respect to paragraph 2 will follow. And then paragraph 3 may
Not only that, my lord,
prayer
now
3 may not be
there
maintainable.
are 319, so Honorable Supreme Court
My lord,
clearly
the
observed.
declaration cannot be sought.
My lord,
Possession
devotees
also has
have
to be
every
taken.
right. Now, my lord, temple is locked. Kindly see my interim prayer. My lord, let them open the temple.
My lord, we are not in possession of the temple. It is the
We have
people
given
who are there.
representation, my lord. Let them consider our representation.
The possession is not with them.
Page 319. May I make one submission, madam? Prayer number 3 in the writ petition to protect the temple and maintain the temple. It's a Mujarai temple. Now it is locked, madam. We have given representation to them. There is also alternate prayer, madam. Notices issued, my lord, let them say.
My lord, in the representation, it says the temple and its properties. That's where, my lord, we have a hitch. Very well.
Lord, now temple is locked and my lord, it is.
Obliged.
Case number 17, Vishwanath Shetty.
Petitioners may ask. Not the petitioners are the residents of one Shetterhalli village, Kasba Hobli, Devanhalli Taluk, my lords. Land bearing survey number 112, which measures about 3 acres, 25 guntas, is a land which was originally a government land, my lord. The said village was a Jodi Inam village. So this land was separately categorized for the purpose of harvesting the crops by the villagers, and that it was called as it is a public thrashing floor, my lords, please. My lord, in respect of the same land, my lords, please, the previously, my lords, please, 5 persons. The farmers who will grow the crops. And in fact, in the said land, there is also a government school is also there. I am informed that. And one dairy is also established there, and as it is a government land. My lords, please, in respect of the said land, my lord, previously 5 persons, my lord, if my lords are pleased to peruse Annexure C, my lord. I mean, Annexure A, I like to take to show. This land is a thrashing floor land, which is in Kannada language, my lords, please. Typed copies are also furnished to the same, which are from page number 30 to up to 70, my lords. Page number 30 up to 70. My lord, after 70, my lords, please, now the respondent number 5 to 11 have got entered their name in the revenue records in page 72, Annexure A. Continuation, my lord. page 72, name of Mallanna, Hanumanthappa, Pujari, Naranappa, some persons, my lords, please, in respect of this land by way of portions of the property. My lord, they have obtained an order from the Tahsildar, my lord, kindly peruse Annexure B. As per the Tahsildar order now, which is under challenge, my lords, please, as if this land was a Jodinam land, and few persons, my lord, English translated version is in page 89, my lord, page 89, second paragraph. And in case number 1 of 1959-60, the Special Deputy Commissioner has granted this land in favor of 4 persons of Shettar village, that is predecessors of the respondents herein, and that they are entitled for the same. My lords, please. Actually, this is a factual thing suppressed by the respond number 5 to 11 for obtaining khata in their favor. Kindly peruse Annexure C for a moment, my lord, please. My lord, for section 94A, an amendment was made to the Karnataka Land Revenue Act. For the persons who are cultivating the government land unauthorizedly, they can make an application in form number 50 to a committee which is formed as regularization of unauthorized cultivation in a taluk area, my lords, please. They made an application, my lords, please. Kindly peruse Annexure C, my lords, please, page 106, my lord. All the 5 applications filed by the predecessors of the respond number 5 to 11, my lord, claiming that they are cultivating this land as unauthorizedly and prayed for regularization of their alleged cultivation. My lord, the Tahsildar has passed an order, my lord. English version is at page number 107, my lord. The Tahsildar, on verifying the records, found that this land was a reserved land for public thrashing floor, and that he rejected their claim. My lord, please, the persons who filed the applications, my lord, who
under section 49A of the Karnataka Land Revenue Act.
My lord, it is an appealable order. My humble submission, my lords, please. My humble submission. Already this honorable court has passed an order. I place it before this.
I appear.
My lords, please. Challenging this order before the Assistant Commissioner under section 136 clause 2, it is provided, my lords, please. It is a public property because on the face of record, an order passed by this honorable court is there in respect of the same land in the year 2004 itself. My lord, kindly peruse the Annexure F, my lords, please. Same predecessors of the same persons who made claim of unauthorized cultivation, filed an application before Tahsildar, rejected. Assistant Commissioner order was remanded. Then Deputy Commissioner order was held that it is a public thrashing floor and it cannot be granted. And then they preferred writ petition before this honorable court. Page number 119 may kindly be perused, my lord, please. If I am permitted, I will read 119, and a typed copy is also placed. This honorable court has also categorically held a thrashing floor and also villagers, my lord. Only, please, my lord. My lord, not interested, villagers, my lord. Not by one person, villagers. And there is a school, my lords, please. There is a school and there is also a dairy, public purpose land. And my lord, kindly, may permit to read, my lords, kindly permit me, my lord. I will read orders of this honorable court, my lord. Orders of this honorable court in page number 119 comments. The same person's predecessors who claimed as unauthorized cultivators of this land, my lord, who failed before the Deputy Commissioner, holding that this land is a public thrashing floor land and it cannot be granted, have approached this honorable court with writ petition numbers 16,502 to 2005. My lord, that 5 persons' names, 4 petitioners' names are referred to therein. May I read this entire order, my lord? That clinches the issue for consideration of my lord that it is a public issue. It's not a personal interest will not be involved because we are villagers, my lord, which has been utilized from 1960. Prior to that also, this land as a thrashing floor, that is only for harvesting the crops, my lords, please. Harvesting the crops, my lord, which are grown by the farmers of the village, my lord. My lord, may I read? I think entire order, if I read, it may clinches the issue in question, whether it is a public interest or not question, my lord, please. My lord, as could be seen from the order sheet dated 29th, no, my lord, I'll take to para 2, page number 121, matter commences. The petitioners have filed these writ petitions seeking for issuance of a writ of certiorari quashing the order dated 27/1/1997, 2/7/1999, and 19/3/2001, respectively passed by the respond number 3 to 1 respectively. And further, they have sought for issuance of a writ of mandamus directing the third respondent to issue a grant certificate in their favor on the basis of the recommendation of the committee as per Annexure C dated 10/2/1993 in terms of rules 108 D clause 3 under chapter 13A of the Karnataka Land Revenue Rules, urging various grounds. Petitioners filed form number 50 applications under section 94A of the Karnataka Land Revenue Act 1964 before the third respondent seeking for regularization of their unauthorized occupation of the land which is claimed by them, which came to be rejected without conducting an inquiry on 27/1/1999, stating that the land in question is reserved for a thrashing field. The said order was challenged before the second respondent, who is the appellate authority, urging various contentions. The second respondent, after hearing the learned counsel for the parties wide order dated 2/7/1999, allowed the appeal and set aside the order of the third respondent and remanded back the matter to him for re-inquiry. The said order was challenged by the respond number 4 and 5 before the first respondent by filing a revision petition in number 84 of 99/2000. Though the second appeal is maintainable under section 50 of the KLR Act, the first respondent, after hearing the respond number 4 and 5, has passed an impugned order setting aside the order of the second respondent and confirming the order of the third respondent. The correctness of the said order is questioned in these writ petitions. It is contended by the learned counsel for the petitioners that the impugned order is in violation of the principles of natural justice, and further the same is in violation of the resolution approved in favor of the petitioners for regularization of their unauthorized occupation of the land in question under Rule 108D of the Karnataka Land Revenue Rules 1966. Further, it is contended that the same is in contravention of the Commissioner's report at Annexure H dated 21/4/1995, submitted in writ petition number 17,488 of 1994, wherein the extent of the land in unauthorized occupation of the some of the petitioners and the existence of the school building and also the nature of the land is clearly stated in the said report, which is in favor of the petitioners, and non-consideration of the said material document has violated the order passed by the first respondent. Further, it is contended that the order passed by the first respondent is contrary to the order of the Special Deputy Commissioner for abolition of INAM in case number 56, wherein the land bearing survey number 112 to the extent of 5 acres is granted in favor of one B.N. Shankar, and therefore it is INAM land, and as such the finding recorded by the first respondent based on the revenue records is contrary to the said order, and this dispute the question of fact required to be examined by the third respondent, which is the fact finding authority. So after affording opportunity to the petitioners, however, the third respondent has not conducted the inquiry. Therefore, the finding recorded by the first respondent with regard to the nature of the land as to whether it is reserved land under section 71 of the Karnataka Land Revenue Act and whether the land is available either for grant of regularization of unauthorized cultivation and also not taking into consideration of the fact of unauthorized occupation of the petitioners as indicated in the Commissioner's report is contrary to the factual aspect, and as such the same is liable to be quashed. Further, it is contended that the finding recorded by the first respondent placing reliance upon Rule 108 I of the Karnataka Land Revenue Rules suffers from error in law, as the land in question, as could be seen from Annexure J and the regrant order passed in favor of one B.H. Shankar and the Commissioner report as per the Annexure H is not reserved land in terms of section 71 of the Karnataka Land Revenue Act, As such, applying the rules 108 clause I of the rules to the fact of the case is wholly unsustainable in law, and therefore it is urged on behalf of the petitioners that the same is liable to be quashed. So the learned counsel appearing for the respondent number 4 and 5 has sought to justify the impugned order, contending that the first respondent, being the fact-finding authority in exercise his powers, has examined the order passed by the second and third respondents with reference to the revenue records, and found that the land in question is reserved for public purpose thrashing field, and it is the government land. As under column number 4 and 5 of the RTC records, it is entered as Sarvatrika Kanada Tundu. That means thrashing floor, my lord, in English, my lord. Then, and that the entries in the name of the first petitioner and the wife of late Gangappa and the third petitioners have been made clandestinely in RTC records, though the lands are being enjoyed by the villagers, and the said mistake has been subsequently rectified by the committee and has rightly applied the Rule 109 Clause I of the KLR Rules 1966 to the case on hand. Therefore, it is submitted that these are not fit cases for this court to exercise its extraordinary and supervisory jurisdiction to quash the impugned order passed by the first respondent as per Annex G. So after hearing the learned counsel for the parties, I have carefully examined the correctness of the finding and the reason recorded by the first respondent in the impugned order. So the first respondent has entertained the petition filed by the respondent number 4 and 5, though the revision petition against the order of the second respondent is available, holding that the second appeal is maintainable before him. So it is an undisputed fact that this court dismissed WP number 17,488 of 1994, in which the recommendation of the committee for regularization of the unauthorized occupation was challenged by the respondent number 4 and 5. Pursuant to the said order, the Tahsildar wide order dated 27/1/1997 rejected the application of the petitioner, stating that the land in question is reserved as a thrashing field, and as such the claim will not come within his jurisdiction. No doubt the said order was not passed by the committee. Nonetheless, the said order was subject matter of the appeal before the second respondent under section 49 of the KLR Act. In view of the rules 108D clause 6, the assistant commissioner has no doubt has exercised his appellate power jurisdiction and found fault with the order of the third respondent, holding that the said order is not proceeded by an inquiry as provided under the rules 108I of the rules. Therefore, the appeal of the petitioners was allowed by the first respondent authority. The correctness of the said order is examined by the first respondent as the second appellate authority. At the instance of the respondent number 4 and 5, the appellate authority has examined the claim and counterclaim of the parties in the absence of the petitioner's counsel. After carefully examined of the finding recorded by the first respondent in the impugned order, this court is not inclined to interfere with the impugned order for the following reason. The first respondent has referred to the revenue records wherein the name of first petitioner and the third petitioner is entered in the RTC extracts under column number 12 class 2 of the RTC record, and he has recorded the finding that the same have been entered clandestinely by the officers, and the same has been subsequently rectified. Further, he has rightly placed the reliance upon the order of Annexure J and recorded the finding that it is the Inam land under the Inam Abolition Act, and the same was granted in favor of one Mr. Shankar. Further, the finding of the fact of recorded by him, stating that both under column number 4 and 5 of the revenue records in respect of the land in question, it has been specifically mentioned as a thrashing field, and at column number 9, it is mentioned as Sarvatrika Kanada Tunda. So the same has been assessed by the competent authority, and the taxes have also been paid by the villagers. Further, the RTC records for the year 1968-69 to 1993-94 furnished by the respondent number 4 and 5 are also examined and has been observed that the name of the first petitioner and the husband of the third petitioner are entered in column number 12 class 2 of the RTC. However, in column number 9, the entry with regard
It appears to be very long judgment.
My lords, please. It's a final finding and the writ petitions are dismissed. It means, my lord, the persons who made an attempt to get this public land, my lord, for themselves have failed. The writ petition is dismissed. With these observations, holding that it is a public thrashing. Now, my humble submission to this honorable court, my lords, please. The villagers are the public, my lord. Their personal interest in the meaning, my lords, please. It is a land specifically reserved for thrashing as a thrashing field. It is nothing but where the villagers, who grow the crops in their lands, my lords, please, will be harvested here. My lord, even if it is not so also. My lord, it is a public land, government land, my lord, and there is a government school, there is a dairy, and it requires for the children and future for further development of that school and other activities. It is undisputedly, my lords, please, as long as in the year 2004 itself, this honorable court, in presence of this order, if further, my lord, where final observations may kindly be perused in page 130, my lords, please. It's a public land. I have not come with personal interest of against the respondents, my lords, please. And earlier also the persons who have opposed the claim made by the respondents' predecessors, who are the petitioners in the previous writ petition, my lord, they are also on the basis of public interest only, my lord, not having any personal interest in the matter. So once again, my lord, can the Tahsildar in persons of Annexure B hold that 1960 land is granted to these persons, my lord, and they were in possession of the same as observed in Annexure B, my lords, please. The Tahsildar being a person who has to safeguard the public land, my lords, please. It cannot be for a villagers, my lord. It is not given to villagers.
Heard learned advocate Mr. So-and-so for the petitioners, and learned additional government advocate Srimati Neelofar Akbar, who appeared upon service of the petition, upon service of the copy of the petition in advance. Paragraph. The petitioners, 10 in numbers, have filed this petition, styling it as public interest petition. Paragraph. What is prayed in the petition is to set aside order dated 31/8/23 passed in RRT case number 213/2021-2022 by the Tehsildar Devanhalli Taluka, Devanhalli, desk dispatch number 4 here. Which is in respect of the land bearing survey number 112, head measuring 3 acres and 25 gutas, situated at Shetarhalli village, Hobli Kasba, Devanhalli Taluka, Bengaluru rural. Full stop. The second part of the prayer is to direct respondent 1 to 4 authorities to restore the revenue entries pertaining to the said land as public threshing floor by removing the names of respondent 5, names of private respondent 5 to 11, entered in the revenue records, and to reserve the same permanently as public threshing floor. The petitioner claims to be the paragraph residents of Shetarhalli village. Their case is that they are their case is that they have been owning, that their case is that they are the owners of their agricultural lands. It is also stated that they are utilizing the said mentioned government land bearing survey number 112 as public threshing floor. for harvesting the crops. It is the case that this one of 5 to 11 made a false claim in respect of the said land, as if they are cultivating the land and sought for regularization. He stated that pursuant to the said claim advanced by the private respondents, from respondent report Tehsildar passed the aforesaid order dated 31/8/23 in the case instituted by the said respondents. On consideration of the pleadings and the subject matter grievance, as well as the prayers advanced, there is no gainsaying that the petitioners have been asserting their rights in respect of the said land survey number 112, which is now subject matter of order in favor of respondent 5 to 11. Not only that, the order dated 31/8/23 passed in case number 122, public 2021, is an appealable order. Case number 213 is an appealable order, paragraph. Under section, an appeal would lie against the said order under section 49 of the Karnataka Land Revenue Act 1964. When the statutory alternative remedy is available in respect of the order impugned in the present public interest petition, the court would be disinclined to entertain the petition as public interest petition. Not only the above ground is awaited to dismiss the petition, looking to the nature of the above is the weighty ground, where above is the weighty ground because of which, on account of which the court would not entertain the petition. Right. Also, while dismissing the petition,
Liberty may be given to.
Observe that at this stage, learned advocate for the petitioner submitted that liberty may be reserved for the petitioner to file appeal under section 49 of the Act. Full stop, such liberty is reserved. It is further observed that if the question of limitation arises, it will be open for the petitioners to take resort to provisions of section 51 and 52 of the Karnataka Land Revenue Act 1964 in accordance with law.
Blind.
Case number 18, Mr. Ramatullah.
I pray for the petitioner, my lord. Lord, the earlier public interest litigation was filed against the same cause of action, my lord. This honorable court has specifically passed an order removing the 24 shops in the public passage in the fire exit, my lord. Your lordship, kindly come to page 68, my lord, operative portion of the order. May I read the order, my lord? page. prayer made by the learned counsel for the BBMP appears to be genuine prayer. Therefore, the respondent BBMP is directed to take appropriate action in respect of the encroachers, in respect of the shops, which are on the pavements, on the road, public passages, as well as the fire exits, and in respect of the unauthorized occupants. The BBMP shall conclude the aforesaid exercise within a period of 3 months from today, after following the due process of law. But instead of removing the shops, my lord, they are again constructing in the same public passage for a fire exit area, my lord.
So they are widening, narrowing the road.
Yes, my lord.
Narrowing the.
Narrowing the road, my lord. The fire engine has to enter, my lord, in the case of fire accidents. The earlier petition was filed after more than 100 fire accidents, my lord. There was a specific direction to the BBMP. They have filed an affidavit in this regard, my lord.
So your stop are getting demolished.
Yes, my lord.
That is the reason.
So they have started construction, my lord, now. So again, they have started construction, my lord.
You will be satisfied with the prayer first or what? Are you satisfied with the prayer one?
Prayer one. That is.
Are they narrowing the road? They are not narrowing the road.
They're not narrowing, my lord.
Oh.
It's ingress and egress of the fire engine, my lord, the people. There are 2,000 shop owners in that market, my lord. 50,000 every day the footfall, my lord. In the festivities, and 3 to 4 lakhs the footfall, my lord. There are hundreds of fire accidents, my lord. Annexure C is the government order, my lord, sanctioning 1 crore for the same, my lord, for constructing the shops. On the contrary to the earlier orders.
So they are constructing new shops.
New shops in the fire exit and the public passage, my lord.
You know, public space.
Public passage.
Heard learned advocate Mr. So and so, so and so. For the petitioner. The petitioner is Bengaluru Flower Merchants Association. Flower Merchants. Full stop. It is the case of the petitioner that King Krishna Rajendra Udayar KR Market, which is one of the first and oldest markets in the city of Bengaluru, is a shopping destination. Full stop. Located off the Avenue Road. The retail center has around 2,000 retail outlets, offering a wide ranging choice of brands and categories to the customers. The grievance of the petitioner is that the respondent authorities have decided to put up additional construction of the new shops in the area, and that the same is being done by utilizing the
public passage in the fire exit area.
It is the grievance that if such it is stated that government order dated 31/3/23 is, which is the order date of the order? Annexure C. It is stated that the government has passed the order dated
11/1/24,
whereby the grant is sanctioned.
sanctioning 1 crore rupees for the same.
Full stop. It is the further case that if the construction is allowed, it will render it extremely difficult and nearly impossible for the ambulance and engine to enter and renders fire extinguishment, etc. services of fire extinguishment, etc. And that the life of the public moving and commuting in the market area would be endangered. It is also stated that in read petition number 5, the paragraph 53474 of 2017, this High Court had an occasion to pass order dated 14/9/21, directing the authorities to take action against the illegal unauthorized occupants who have constructed the shops on the pavements, public spaces, and at the points of fire exit, AEXIT. Is stated that a large number of people come to the market whose safety would be jeopardized if the construction on the passage is permitted, on the pathway and the road is permitted. Notice to the respondents returnable on. For the time being 18th of December.
Much of it.
Bill number 19, G.R. Mohan. If this matter pertain to the bylaws, now I filed my suggestions. Filed by suggestion as per the order of this court on 224. And now they filed a reply also. Copy is served on me.
You are appearing?
Yes,
I'm in a connected petition.
So now what?
Petition is 57990 is there. The Server Court passed an order on 12th August and also on 22/10/2000. The bylaws now finalized by the BBMP, Urban Development, will be subject to fees of the subject matter of present public there. The monitoring and regulation of so and so have been put up without first being produced on record, present closing are approved by this court. So accordingly, now bylaw is placed on record. For that, I was also required to file my suggestion and that also I filed it.
You filed it.
Yes, sir. That was filed on 27th.
Filed on 27th.
7th November.
The bylaws are placed before the court.
The bylaws have been already placed before my earlier, and by that
you do one thing. Just separate the suggestion and by we will dispose it of.
No, one submission. If the bylaws are either
approved or disapproved by this honorable court, the right of judicial review will be taken away. It is a legislative act. Kindly allow them to have it. We'll avail our remedy under Article 226. Because it amounts to prior censorship of the bylaws. If I, with
We are not,
due respect-
we are not in any way will be closing the challenge if permissible to the bylaws.
No, they are now placed before the court.
So-
Court has injuncted them from operating it without the prior approval.
Even if we permit to implement the bylaw, that will not mean that you are not entitled to challenge the bylaw.
No, in that event, the whole exercise of considering it for approval or disapproval may not be necessary.
So you don't want us to approve?
No, with great respect, all that I am saying is let them, please allow them to publish it and
No,
operate
that will
it.
do, that will.
Operate it.
Correct.
Subject to the remedies available against it.
Against the bylaws. Yes, that will do.
That's all my prayer.
That will do. It was only because the petition was pending, we have said that you just take
It
approval.
shall not be operated without the prior
Now,
approval.
once it is disposed of,
So it may now be clarified that the bylaws may be given effect to.
any suggestion about bylaws?
My lord, as against the suggestion which my learned friend, my lord.
Only we wanted that the
State-wise. We wanted it.
Where is the bylaw?
This is the reply to his suggestions. A memo has been filed.
No, objections were allowed to be considered and they have been considered. And thereafterwards, the bylaws have been framed. So therefore, further consideration may not arise is my very respectful submission.
will not say anything, will permit them to operate the bylaws, subject to all challenges
Please.
which may be.
Please.
Filed including applicants as advertisement agencies.
Pardon?
BBM, Lord, we filed 3 applications to implead before the court as the impleading additional respondent. Lord, our grievance in this matter, my lord, is that BBMP has issued a tender to advertisement trade on the PPP project. We are all the PPP project, madam, not a private-public partnership. We built and constructed the skywalks, and on the advertisement basis, my lord, our my lord is in view of this bylaw, my lord, we filed an application before the court. We already filed an objections to this bylaws, my lord, which is contrary to some of the provisions in the earlier old bylaw 2006 and 2018. For the PPP project, hoarding the advertisements, my lord, is concerned, hoardings and flexes, my lord. Therefore, my lord, my application may be considered. Anything is aggrieved by that, my lord, we are liberty to challenge contrary to the provisions of the
Which
bylaw.
application?
But this new bylaw, my lord, is earlier old bylaw, my lord, is tax fee with regard to the PPP project.
We are not examining bylaws in the, as such in this petition. Whatever remedies you want to exhaust in respect of bylaw, its operation, grievance, you do it independently.
Formally, my application may be allowed and the
What?
impleading application will be filed by the the
Which
impleading applicants.
application?
Today, my lord, the-
Impleading application?
Yes.
Now not necessary. By disposing of.
In fact, my writ petition is against them. They have been enjoying a free feed
We are all
without paying any
tender, we are
tax,
paying-
without taking any prior permission. For
Challenge separately, it has
Who
been
are,
challenged.
who are they? Who are you?
We are the advertisement agencies, my lord, on the public
That has been
private.
challenged separately, my lord.
There is a
For
tender,
6
we are the
years.
highest bidder. We are the highest bidders in the tender issued by the BBMP.
Challenge, my lord. On 22.
For 6 years, they have enjoyed the right of advertisement without paying any tax, without taking prior permission.
Made all the.
They have no, they are not entitled. In fact, that is,
We
my
are
writ
all the
petition is
bidders.
against them.
On the tender, we are the highest success bidder.
Separate cause of
Today is
action
what?
and submission.
Today is
On 22/11/2019.
So
Your lordship.
we'll say for orders on 13.
On 22/11/2019.
What is this?
The Honorable Court rejected all those impleading applications, 22/11/2019.
My agreements are subsequent, my lord, in 2019, after order, my lord, passed by the Honorable Court. BBMP, my lord, has executed fresh agreements.
We'll pass, for orders on 11, so that you can at the earliest
Yes, ma'am.
notify
Please.
for 11. We'll pass we'll need some time to at least dictate you.
Can we go on with the advertisement policy?
You can go on 11th will be formally will.
Oblige.
Wait for 2-3 days, so that since order is operating, you will.
Submission, my lord, to defray the cost, my lord.
Well, it's a different cause of action.
We are not entertaining anything as far as you are concerned.
Yes.
No implement application will be entertained once the petition is.
But they are liable to pay. They are liable to pay.
They may pay.
They are not paid a single penny tax.
They may pay, you take a.
The action has been taken, my lord. It is before the.
We are not taking note of your presence at all.
On 26th of.
Whatever your liability, whatever the rights is there, you and.
Please.
November 2019.
Pardon?
Similar 22/11/2019, detailed order was passed by this court. The all of these advertisements want to come on record. All the IAs have been dismissed, your lord. 22/11/2019. Now again they are coming for 2018 bylaws. Earlier bylaws.
All those things will operate.
They are given.
All those things will operate once we dispose of the petition.
Oblige.
2023, my lord, is completion certificate given by the BBMP.
Keep it on 11.
Date?
Still number 20.
For the petitioner, my lord.
Varun Shetty.
20.1, I appear on behalf of the amicus, my lord. There's a slight inconvenience today, my lord. If a date could be fixed.
25.
20.1, my lord.
20.1.
Respondent number 5 and 20.1, my.
Oh, this is the delay.
Please, my lord. The matters will all have to be heard together, my lords.
So when shall we proceed?
Any day. And for respondent number 2 in the first matter. For respondent 3 in the first matter.
Somebody wants time.
The amicus, my lords, that is appointed by this honorable court in 20.1 is seeking time.
So then all will go together. What is 20.1?
Please, if I may, my lords, 20.1 is a suo motu petition initiated by this court, taking cognizance of the failure of the state authorities to take action in respect of illegal and unauthorized constructions. There are several orders passed by this court in that matter. Serial number 20, my lords, which is filed by me, is in respect of the amendments by the KERC to their regulations, granting electricity connections to persons without production of sanction plan or occupancy certificate. My lords have therefore noted that there will be heard together. The matters will have to be heard together, my lords.
Really little time before the holidays. But we'll try on 16th.
16.
Subject to
Pleasure.
availability.
Please, ma'am. Good evening.
16. Is still number 21.
Lord, I appear for the petitioners council. This is that PETA matter, my lord. They said that they are constituting a committee and that they will give a report with respect to Pilukula, where the first race was supposed to be. We have not received any report as of now, my lord.
My lord, I appear on behalf of the state. My lord, we need some time, my lord, to submit the report. If my lord could grant us some.
So, Mr. Chinnappa, when shall we keep, madam?
My lord, Kambala will not take place during the month of December. So if my lord could have it on the reopening, my lord, then we'll file the, provided it is convenient to, my lord, the learned senior counsel.
Yes, ma'am, anytime. Whenever the state gets its report.
Can go to 21st January.
Waive.
22nd, 23rd January.
Obliged.
Waive.
Submission will be taken
My
on,
lord,
the submission will be taken on next order.
What's the law and additional government enterprise?
My lords, may I request for 24th, my lord.
Raise for time. By submitting that, the report of the committee, which is already constituted, is awaited. Full stop. She further states that the event Kambla will be
yes,
recorded,
yes, December.
not going to be conducted in any case in the month of December. In that view, as requested by the
Will not be
councils,
conducted in Pilicula, my lord, not other places we are conducting, only in Pilicula. Yes.
event in question shall not be conducted in the month of December. At the request of paragraph, all the councils appearing for the respective parties. As agreed, stand over to 24th.
Waive.
What is the?
Very well,
time?
Lord. 24th.
My lord, could I make one submission, my
24th.
lord?
24th.
My lord,
Wait.
could I make one
20?
submission?
24th, all right.
My lord, could I make one submission? Could my lord have this on 7th tentatively, my lord? In case if there is some emergency, then we'll make a submission. Otherwise, it can spill over to 24th, my lord.
Then 10th January.
Obliged.
Grateful.
Reinvent matters, seal number 22.
You would appear for the petitioner in this case, please.
22. What is it?
Petitioner, my lord, in this case has challenged the order asked by the respondent to produce at annexure R place. Identical matters, my lords have already disposed it of on 11th November 2024, where the survey number, village, the impugned orders are all same, my lord. May I pass it on, please, my lord.
Yes, sir.
Issue notice.
My lord, it's covered by my lord's decision.
My lord,
Covered.
please.
Thank you.
Acha. Hearing. Same line. Order on same lines.
Please.
Obligement.
Disposed of. 20.
22.
22.
Seal number 23. Ravindra Gajan.
Please, my lords. Herein I am for the petitioner. Petitioner is challenging the notice issued by the licensing authority produced at annexure A, my lords, threatening to stop the stone crusher unit, my lords. Directing the assistant commissioner to, or
only at the notice stage.
Show cause notice, my lord.
My submission. This reputation is not maintainable because of the bar contained in the Air Act. And
Petition complaint not maintained.
Lord, that contention can be taken before the authority concerned, my lord. It's
No,
like
that's
educating him also.
What is not maintainable?
because there is a bar contained under Air Act that this reputation is based on a suit filed before Indi Civil Judge Court, wherein a permanent injunction could not be obtained by the complainant.
So then it is your petition.
No, a writ petition is mine, my lord.
Then which petition not maintained?
But what I am submitting is the proceedings initiated by the licensing authority.
That also you can take raise objection.
Yes, my
In
lord.
the reply.
We have already submitted the reply, my lords. At annexure K at page number 56.
This petition filed under Article 226 of the Constitution. This petition filed under Article 226 of the Constitution makes a prayer to set aside notice dated 25/10/24 issued by respondent number 3 dash the Deputy Commissioner and licensing authority, District Stone Crushers Licensing and Regulatory Authority, Vijayapura. He stated in the notice inter-alia that in respect of land bearing survey number 72/1 at Portnala village, Indi Taluka, the competent authority issued license in Form C in respect of area of 2.10 acres in favor of one Messrs. M.Y. Stone Crusher, which license came to be transferred by the said M.Y. Stone Crusher in favor of the petitioner hearing. He stated that once the Umalu raised objection to the transfer of the Stone Crusher license, which is for a period of 20 years. The said Umalu has stated that transfer of the Stone Crusher license should not happen till the disposal of the original suit number 221 of 2004 file be instituted before the Court of Civil Judge Indi in respect of certain extent of the said survey number. It is stated paragraph that the Assistant Commissioner inspected the stone crushing operation in the area and noted that the crushing operation have been creating disturbance to the surrounding environment and also to the agricultural activities. It is stated that the additional Deputy Commissioner has instructed by letter dated 31/8/24 regarding cancellation of stone crusher license in favor of the existing stone crusher license, which is in favor of the petitioner in view of the report submitted by the Assistant Commissioner. Period. The show cause notice is issued following upon paragraph the petitioner to show cause as to why the stone crushing license and activity should not be suspended in terms of section 10 of the Karnataka Regulation of Stone Crushers Act 2011. Full stop. There is no escape paragraph from the fact that the challenge is only to the show cause notice. Full stop. The petitioner is asked by the authorities to submit its explanation to what is stated in the show cause notice. The petition is premature. Also, the petitioner will have right to raise his defense and submit and put forward.
We had already submitted the reply.
Filing reply. Are you giving hearing also?
My lord, if my lord says, then we will provide them a hearing.
Learned additional government advocate would submit that if the petitioner applies, the authority may also consider giving personal hearing to the petitioner. Full stop. In the aforesaid view, the petition is not entertained since it is only against the show cause notice. The High Court will not exercise its jurisdiction on Article 226 of the Constitution. When there is no final order is passed and the petitioner will have opportunity to put forward his case. Full stop. Leaving the petitioner with liberty to file reply and also to request the authority to give personal hearing. This petition is not entertained without going into and without expressing anything on the without expressing any opinion on the merits. Full stop. Learned advocate would submit. Learned advocate petitioner, Mr. So and so would submit that the authority had no jurisdiction, had no authority to issue such so-called notice.
Civil court, Indy.
That is a different thing. That
Please,
is
my lord. But only now I am praying that the deputy director,
learned advocate, Mr.
a
so-and-so,
time frame may
so-and-so
be fixed, my lord. Outer limit.
submits that all contentions may be permitted to be raised before the authority in reply to the so-called notice. Full stop. Such the petitioner may raise all the contentions as may be available in law. Full stop. With the aforesaid observations, the petition is not entertained.
An outer limit for the licensing authority to dispose this matter. Otherwise, they will keep on the long so that I may not be able to operate the.
Not
store.
entertained with direction, however, that the exercise of
4 weeks.
deciding the proceedings pursuant to the so-called notice shall be completed within 6 weeks, provided the petitioner files his reply within 10 days.
Obliged.
Please, my lords.
Number 24, writ appeal matters. Higher please.
The appellant, your lordship. Your lordship, appellant is the grandson of the grantee who had received under the provisions of grant land 2 acres of land with a condition not to alienate the same for a period of 15 years. But without complying the condition, the property was sold in the year 1965. And in the year 2014, the grandson had filed petition before respondent number 3 to reinstate it back in favor of the grantee and his legal heirs. And respondent number 3 was pleased to allow the said petition. Agreed by that order, respondent number 9 filed appeal before the respondent number 2. The said appeal was withdrawn by the respondent number 9, stating reason that the land belongs to the government and the respondent number 9 has no right over the property. Aggrieved by the order passed by respondent number 3 and 4, respondent number 4, 5 and 6 filed writ petition. And the said writ petition order was passed by the learned single bench that the
Delay of 35.
35 years delay, my lord.
We have-
35 is a
Your
grand
lordship,
order.
latest amendment to PTCL Act, it says that section 5 is not barred by limitation. It can be invoked.
Then there is a decision of the division bench, Dharwad.
Please,
Dharwad.
Rakhi
Have you
Prasad.
seen that? Have you seen that? Justice Dixit and Justice
Vijay Kumar Patil.
Justice Dixit and Justice Patil.
Patil.
Have you seen that?
No, Your lordship.
See that and come at 2:30 on Monday.
Please.
Yes, Your lordship.
Then make your submissions after understanding everything.
I will, Your lordship.
Madam. 25 adjourned. Still number 26. Sir, Dodwad.
26, I am appearing for the appellant.
20.
My lord, I am appearing for the appellant. My lord, the appellants are challenging the order made by the learned single judge, my lord, is 2nd November 2023, whereby, my lord,
my lord, the order of the learned single judge, my lord, whereby, my lord, the direction was given to the appellants to issue an appointment order to the second respondent. Lord, what happened, my lord? The first respondent is the father of the second respondent. My lord, was the employee of the appellant, my lord. And my lord, the appellant says introduced a VRS scheme on 19/1/2006. Lord, under the said scheme, my lord, the employees of the certain categories of the corporation who are medically incapable of continuing their work, Lord, they were given the retirement benefits, and my lord, their one defendant would be given the employment. My lord, the first respondent was applied for under the said VRS scheme in the 2006. My lord, in spite of that, my lord, his request was not considered by the appellants. Again, my lord, he made a representation on 2010, where the medical board has again reiterated for his incapacity for the continuation of the work. My lord, in 2010, my lord, the appellant corporation has accepted his request. My lord, permitted him to retire with effect from 30th of June 2010. My lord, under the said scheme would be applicable to the employees between the age gap of 45 years to 54 years. My lord, in the 2010, when this first respondent was permitted to retire from the services, my lord, he was 57 years. Though, my lord, all the retirement benefits under the scheme was extended to him, my lord, the employment to his dependent was not given. Lord, challenging that, my lord, in 2013, they filed the writ petition. My lord, learned single judge allowed the writ petition, my lord, on the ground that though the medical board has opined that he was incapacitated to continue in the employment, and the KPTCL ought to have retired him from the service when he was within the age limit, and ought to have given the employment to his son, my lord, who is the second respondent before my lord. May I request my lords to the observation of the learned single judge is page number 17, my lord, paragraph 8, my lord. May I read, my lord, paragraph 8 is page number 17. No, my lord, the learned single judge further directed that the appointment should be given to the second respondent, not taking to his present age. Now, my lord, as per his date of birth in the school records, now he is, my lord, 44 years. Lord, as per the corporation rules, my lord, the maximum age for the general merit candidate is for 35 years, my lord, and scheduled caste members is for 38 years.
At the relevant time, you would ignore the medical certificate.
Please, my lord, even under the scheme, my lord, it was a power was given to the corporation to consider or not. May I request my lord to take to my lord to relevant page.
It is in which year?
My lord, in 2000, my lord, that was in 2006, my lord.
2010, 6.
2006, my lord, first application.
So as on date, the son is of 44 years.
My lord, as on date of writ petition is order made, my lord, on the, he is on 44 years, my lord.
On the date of writ petition, he was of?
My lord, he was 34 years, my lord, 2013.
Within limit.
My lord, that's true, my lord. My lordship may kindly see, my lord, the power was given with the corporation that, my lord, accept the VRS scheme or not. May I request lordship may kindly turn to page number 104, my lord, where the scheme begins, my lord, English version. My lord, conditions of the scheme you will, my lord, find at page number 106, my lord. Lord, 104 scheme begins. My lord, condition number 1, page number 106, my lord. Only permanent employees from 45 to 54 years are eligible for this voluntary retirement scheme. My lord, I will skip condition number 2 and 3. My lord, condition number 4, managing director has the power to accept or reject the request for voluntary retirement under this scheme. Therefore, my lord.
So what happened? The father was accepted voluntary retirement.
My lord,
Request was accepted?
In 2010 was accepted, my lord. In 2006, that request was not accepted. He was continued.
So in 2010, what was the age of the?
My lord, he was at 2010, he was 57 years, my lord. All the retirement benefits under scheme were extended to him, my lord. Only appointment to his son was not given.
In 2006, he was. This is writ appeal number 389 of 2024. Our learned advocate, Mr. So-and-so for the appellant. The appeal is directed against judgment and order dated 2nd November 2023 of law in a single judge whereby the petition came to be allowed. The prayer in the writ petition filed by the respondent number 1 and 2 was
Page number 34.
to direct the respondents to provide appointment to a suitable post to petition number 2, in view of the voluntary retirement of petition number 1, who was the father from service. It is not in dispute that the appellant Karnataka Vidyut Prasar Nigam has framed a scheme for voluntary retirement for its employees. Full stop. The employees in the age group of 45 to 54 years are permitted on the medical ground. Full stop. Under this scheme, where an employee is found to be medically unfit and becomes entitled to retire under the scheme, the dependent children will be offered an appointment. Full stop. The object of the scheme is to see that the family of the employee who goes on who retires voluntarily due to who voluntarily retires on account of in view of his medical condition, do not suffer and get a job. Paragraph. Noticing in the above background, effects of this case, the petitioner filed an application on 22/3/2006 when he was petition number 1 filed application. The petitioner number 1 submitted an application for voluntary retirement on 22/3/2006. Full stop. At that time, the petitioner was within the age limit and was aged 53 years and 10 months. Along with the application, he produced the certification of the doctor that he had a disability described as COPD, that is described as chronic obstructive pulmonary disease, into brackets COPD, which was a congestive cardiac failure. The doctor who examined the petitioner and granted the certification as above entitled the petitioner to voluntarily retire. Paragraph. For the reasons best known to the appellant, the petitioner was not permitted. Full stop. His services were continued to be obtained. One more representation was made by the petitioner. The respondents required the petitioner to undergo the medical examination again on 21/5/2010. Full stop. The result and diagnosis of the medical examination was same, and the petitioner was adjudged to be not fit medically to continue in service. The petitioner was ultimately permitted to retire in the year 2010. Retire voluntarily in the year 2010. Full stop. The appointment to petitioner 2's son was denied. Paragraph. On the ground that when the petitioner was relieved from service, his age was 57 years. And that he was not in the age group of 45 to 54 years. Full stop. This ground would readily fall flat. Fall flat. Inasmuch as it is not in dispute that it was in the year 2006 itself when the petitioner was 53 years and 10 months old, he was diagnosed to be not fit medically with certification of doctor, and consequently was entitled to seek to have the voluntary retirement granted. There is no explanation coming forth as to why at that time the voluntary retirement was not permitted for the petitioner. The petitioner was made to undergo the process again in the 2010. Full stop. The result was the same. And finally, the appellant had to retire the petitioner voluntarily giving benefit of the scheme. Full stop. Learn a single judge. Paragraph. In light of the above operative facts recorded following findings in paragraph 7 of the order at page 16, paragraph 7, the recorded portion. The honored single judge thereafter observed that having regard to the conditions of the scheme, the petitioner was required to be granted voluntary retirement in the year 2006 itself. However, in any case, from a year delay in that regard, leading the petitioner to attain the age of 57 years could not be a ground not to give appointment to petition number 2 under the and deprive him the benefit of the scheme. Learned paragraph. A vain attempt was made in course of the hearing by learned advocate for the petition appellant that at this stage the petitioner number 2 has crossed the age of 35 years. Full stop. This argument, this submission could hardly sustain inasmuch as when the right accrued for the petition number 2 to be when the right accrued for the petitioner to be to voluntarily retire and consequent right under the scheme became available to petition number 2 to be appointed, both the petition number 1 and 2 were within the frame of the conditions of the scheme and were within age limits. Paragraph. When a single judge therefore rightly observed, extracting paragraph 9, then bracketed portion, paragraph 9. The fact that the petitioner was subjected to another examination. Scheme formulated. Learned single judge has rightly was eminently justified in granting relief to the petitioner. Observing that the petitioner, petitioners though were entitled to, had to litigate for 10 years for no fault of their own. Full stop. No error is booked in the approach, in the judgment and order of learned single judge. Paragraph. Full stop. This court is entirely in agreement with the reasons recorded and the final order passed by learned single judge. Paragraph. This appeal is meritless and the same is dismissed.
Because the delay. 27, 28 are urgent. Number 29. Mr. Rayappa.
What is it about?
The appellant, my lord.
Appeal.
My lord, the appellant is a Sikh company, my lord. The learned single judge passed an order directing the appellant to pay interest on the EL encashment, my lord.
Delay.
Page number 22, my lord.
Interest, only interest. What is the interest? 6%. Delay of 10 years, 11 years. 6%.
In similar matter, my lord.
6%.
Because the Sikh company, my lord, is not able to pay even the petitions. Lord, in similar matter, Lord, similar matter, the single judge passed an order, right? That order has been confirmed by this without interest, Lord, in other matter.
In other matter.
This is same company, Lord. Without interest, Lord, the learned single judge passed an order directing to pay the yield encashment. And this honorable court has, in fact, confirmed that
we can
extended the time.
We can follow if the interest is set aside. But interest is not granted and confirmed will not prevent us from dismissing this.
My lord, it's a company, my lord, it's a district company, my lord, they are not in a position to even pay the salaries to the employees. And the statutory dues are, my lord.
Same
order,
same
my lord, page number, Lord, your lordship has extended the time also. In writ appeal number, my lord.
Page number?
Page number 13 to 13, my lord. Page number, my lord, 21, my lord. My lord, operative portion is at page number 23, my lord. 23, my lord. Para 3, my lord. As the company undergoing loss and subjected to financial difficulty, only to give a fair opportunity to the appellant, we deem it appropriate to modify the order of so and so, not single judge, particular direction so and so, by extending the period granted by the runner single judge. Runner single judge granted 6 months, 4 months time to pay the yield encashment. And this honorable court has extended the time frame, Lord. And the next appeal also the same, Lord. Because otherwise everybody will come approach and seek for.
Interest is not yet to pay, make the principal amount is extra.
In the other matter, Lord, this honorable court has taken a lenient view because of the sick company.
Interest was not granted.
In that matter, the interest was not granted.
Hard learned advocate, Mr. So and so for the appellants. The challenge in this writ appeal is addressed to judgment and order dated 2nd April 24 in writ petition number 453 of 2024, which was filed by the private respondents herein. Full stop, learners, comment to the extent that learner single judge has only interest part.
Only interest part.
Learner single judge directed to pay interest at the rate of 6% to all the petitioners. Full stop. The dues were salary dues. What are the dues?
Due,
The
my
dues
lord,
were
due, my lord, it's already been paid, my lord.
the dues which were payable to the 3 petitioners were in respect of leave encashment.
It has been paid, my lord.
Though they are paid, the actual payment was made quite belatedly. The due dates for payment of leave encashment to petition number 1 was 1/1/12, to petition number TO2, to petition number 2, it was 1/5/12, and the petition number 3 was to be paid the leave encashment on 1/1/12. However, the date of actual payment, however, the amount was actually paid on 4/10/23. Full stop. Paragraph. Learner single judge has noticed the large delay of 11 years and 10 months, 11 years, 5 months, and 11 years of 10 months for the 3 petitioners, to observe that such prolonged delay in disbursing the leave encashment, which was a rightful and legitimate due for the petitioners, would entitle the petitioner, would entitle the petitioner to earn interest on the amount. Accordingly, 6% amount is directed to be paid on the respective amounts of rupees 1,82,935, 1,88,115, and rupees 1,92,708 to the three petitioners in that order. To be paid from the date of payment, to be paid of, from the date, it was from the date when it became due till the date of payment.
In fact, they have.
Full stop. In exercise of appellate jurisdiction, no interference is called for. The judgment and order of learned single judge in granting the
In fact,
said to be eminently proper and reasonable in the totality of the facts and facts of the case, dismissed, the appeal is dismissed.
no, once again, this
Pardon?
operated as a precedent on other matters, because everybody will approach now, not, because there are thousands of employees who have retired. They have accepted the EL encashment without interest. In fact, these respondents also accepted in the contempt petition. They filed a contempt petition, we have paid the amount. At that time, they have not raised any objection. Thereafter, they filed the another writ petition. Therefore, my lord, now everybody.
No. Have you stated it the way it was the case before? Have you stated before learned single judge?
Yes, we have stated, my lord, but learned single judge is not considered that aspect of the matter. Our contention have not been considered at all in the writ petition.
But this is not the judgment in RAM.
Kindly observe that, my lord, it shall not operate as a precedent for other matters.
Yet we can't.
Because now everybody will come in, because the sick company, my lord, they are not in a position to pay even salary to the employees. And the statutory dues are pending.
These are the judgment in personnel confined to, that much we can say.
That's is only applicable.
used to
This
RAM,
matter,
then
my lord,
nobody can.
only one observation, my lord.
And the
Otherwise,
only thing that judgment you cited didn't, but it was not in relation to the interest payment. Otherwise, we could have considered. It was about extension of time to pay them, not
in
interest.
that case, learned single judge only ordered the EL encashment, not ordered interest.
There is no precedent before us that interest is not paid.
Like, my lord, one
Or
single judge-
non-payment is confirmed.
one learned single judge
Non-payment of
passed an
interest.
order without interest, and learned single judge has passed an order with 6% interest. There's a conflicting judgments, my lord.
Write down. In the facts of the present case, comma, in the facts of this particular case, comma, and in view of the reasons supplied by learned single judge, no interference called. That much we can say, whatever it means.
December 30.
In facts of this case,
They
that's
they
all.
will use this judgment for other matters. Everybody will come, my lord. That's why, my lord, one observation, my lord.
We are saying that in facts of this case,
My lord, may kindly, this will not operate as a precedent for
that
other
week,
matters.
the Supreme Court said that you can't say that. You can't pass such an order. That
Court
you
has
can't.
passed in so many orders, my lord.
We are saying that it is in facts of this case, no intervention. That's all. We will not even write the reasons of, any of the reasoning of learned single. We'll say in the facts of this case, no intervention for. It means that what you want, but you can, it's for you, you are the lawyers, better argument makers than the judges. Isn't it? Yes.
December 30, Mr. Shekhar L.
Conductor Milan. Allegation of not closing the entry and non-issuance of one ticket and not collected the fare of ₹12 million. The disciplinary authority initiated disciplinary proceeding. Before the disciplinary authority, the appellant examined the driver of the bus and established that, the bus was not reached at stage point. And the question of closing the entry does not arise. And also examined the driver, the alleged ticketless passengers boarded the bus just then.
Nothing to be. It is not effective. I thought there is nothing.
For the inquiry officer, established that, the bus was not checked the bus at stage point and also established that, my lord, the alleged ticketless passengers not traveled from Sumnali to Sunkatkatte. In spite of, my lord, the findings, evidence adduced by the workman, my lord, before the domestic inquiry, my lord, the inquiry officer, my lord, without considering the same, held that charges are proved. Even the London single judge also not appreciate the evidence available on record properly, my lord. Not the evidence, the driver evidence, my lord, at page 86, my lord. Simple charge, my lord, one is, my lord, not close the stage entry and non-issuance of one ticket of ₹12. In fact, my lord, that fare from that place to that place is only ₹9. They alleged falsely, my lord, is ₹12. That has also been established by the workman. Worship, driver statement, my lord, at page 86, my lord, translation copy of English.
So he was dismissed. You are dismissed.
Yes, ma'am. Dismissed from service, my lord. The labor court set aside the punishment order, my lord, ordered for reinstatement with continuity of service without consequential benefits and without back wages by imposing 3 annual increments with cumulative effect, my lord.
You were earlier dismissed.
Yes, my lord.
Then this order is in your favor.
No, my lord, before the labor court, my lord, the labor court, without properly appreciate, my lord, imposed the punishment of reduction of 3 increments with cumulative effect while setting aside the order of dismissal without consequential benefits, my lord.
You are not dismissed.
I am dismissing from service.
But labor court substituted the penalty with?
The labor court substituted the punishment of withholding 3 increments with cumulative effect and denied consequential benefits, my lord. That portion, my lord, the workman questioned this award. Management also questioned the very same award. The Honorable London Single Judge, my lord, dismissed the writ petition filed by the management and partly allowed the writ petition filed by the workman, my lord. Even without considering the evidence adduced by the workman before the labor court, my lord, he established that, my lord, the bus was not checked at stage point and he has still time to issue the tickets. Lordship may kindly see the evidence of driver, my lord. Driver is the eyewitness to this incident. Lordship may kindly page 86, my lord. English translation, my lord.
There is nothing in the, on the contrary, it is further, you are reinstated with continued service, reduction of 3 increments from 2 increments.
But by virtue of non-extending consequential benefits, is again stand to lose another 2 increments, my lord. By virtue of this order, my lord, is stand to lose 4 annual increments with cumulative effect. At least, my lord, but if the court granted consequential benefit during that period, my lord, he is entitled for increments, my lord. Otherwise, my lord, you stand to lose 4 annual increments with cumulative effect for no fault in.
Lord learned advocate Mr. So-and-so for the appellant. The challenge in this writ appeal is directed against judgment in order, common judgment in order dated 17th March.
No reasoning is assigned by the London Single Judge, my lord, to deny these benefits, my lord. Lordship may kindly see the order of the London Single Judge, my lord. My lord, in this case, especially in this case, my lord, the workman is totally innocent, my lord. My lord, he examined the driver, my lord, and established that, my lord, the bus was not checked at stage point and he has still time to issue the tickets. The witness was cross-examined with the management, my lord. Lordship may kindly see the Honorable London Single Judge order, my lord.
You have started the dictation.
Right.
Till you want to argue, you are welcome to argue. You are welcome to argue. Yes.
Well, your Lordship may kindly see the London Single Judge order, my lord.
Yes.
My lord, in para 6, my lord, page 16, my lord. Page 6, my lord. Page 16, para 6, my lord.
Can we go into the appreciation of evidence at this stage? After 3 authorities have dealt with your case.
But
and you are guilty of the charges of misappropriation, not issuing tickets,
facts remains that,
issuing,
my lord,
issuing the tickets of previous day.
Yeah?
Issuing the tickets of previous day, non-issuance of ticket to one passenger, not collecting the fare.
My lord, that charge, my lord, regarding first
All
charge,
are in the realm of
first
misappropriation.
charge is not proved, my lord, as held by the honorable under single judge, my lord. As per second charge is concerned, when the bus was not checked at stage point, my lord, still they had time to issue the tickets, my lord. This has been established by the workman before the inquiry officer, my lord. Even, my lord, the both authorities are not properly appreciate the evidence adduced by the conductor and the driver of the bus, my lord.
You are praying for stay of the order.
No, I am not saying. I am not granting, seeking any stay, my lord. Lord, Lord, the order passed by the labor court and the order passed by the honorable single judge, my lord, can be modified to the extent that, my lord, is entitled for consequential benefits, my lord.
Sorry, dismissed. Will pass the orders, yes.
Number 31, to Prakasham.
Finally, vacation. At the request of law and order to the appellant, stand over to 22nd January.
Number 32, to Srinivas V.
Are you aware of the Dharwad bench judgment? 51. Are you aware of the Dharwad bench judgment?
Yes, my lord.
What is that judgment? If you are not aware, come on Monday. at
Monday at 2:30.
Monday.
Hear the judgment.
May I make a submission? Your
My lord, I have submission to make. Lord, I have submission to make. Serial number 49 may be taken up in urgency. Serial number 49, 49.
It will reach, mister. It will
Today
reach.
afternoon.
It will reach. It will reach, bound.
My lords, serial number 109, my lords, 109. Kindly have it for tomorrow, my lords. It's an education matter, my lords, with regard to appearance in the examination, my lords. On 29/11, my lords, last Friday, writ petition was dismissed, my lords. Subsequently, we filed the appeal on 30th, my lords. We could not receive the certified copy, my lords. Hence, my lords, the office objections are raised.
Serial number.
109, your lordship.
What is it about?
Education matter, my lords, with regard to additional attempt, my lords, MBBS course.
109 rate appeal is there?
My lords, exams are commenced, my lords, from 2nd, your lordship.
Commencing on?
Already commenced, my lords, from last Monday. That's the urgency, your lordship. Kindly have it for tomorrow, my lords. We have received the certified copy, my lords,
Day
yesterday.
after tomorrow, give me.
My lords, students have already missed 2 examination, my lords, today and day for yesterday, my lords. We could not receive the certified copy, my lords, of the order. That's the reason, my lords. That's the office objection, your lordship. Kindly have it for tomorrow, my lords.
Argue today.
Certified copy, we received it today, my lords. We are placing it on record today, my lords. We filed it in the counter. It is not put up, my lords.
Today you argue, it is available, copy is available. Get the copy and produce in course of the submission. 230, in the 230 matters will take up 109.
Please.
109, other matter mentioned 49. We'll try to take up, no commitment, but 49, 71. No.
39 I will be withdrawing.
14. Pardon?
Withdraw.
Serial number
Yeah.
110.
You want to withdraw the appeal?
Withdrawing. 110. PIL. Let us say at 2:30, what is PIL?
My lords, serial number
Come at 2:30.
39, my lords. I'll be withdrawing this appeal, my lords.
2:30.
Yes, my lord.
pray for adjournment, 90 year.
You want
Till
to?
number 90.
90.
90.
Complainant.
90.
90. List one.
So what do you want? What do you want? What is the request?
My prayer is your, age person. 230, I don't have much argument. 230 hearing may be given. I will be much obliged. 89 years of my age.
Today itself will take up.
It may not reach your lordship.
It will reach, it will reach.
I am already tired, exhausted, sitting.
It will reach. Today there is no 230 parted matter. Therefore, today is the day when whenever request has come, we have taken up. We are going to take up.
If it's possible, your lordship.
We are taking up, sir.
Prayer, your lordship. I'm
Yes.
absolutely tired. I'm finding it unable to.
If you are going to appear,
If
if you are going to appear, we'll take up first. If you are tired. Very first matter will take up after mentioning. Today itself. Yes. Looking to your age, you will take up.
Serial
Yes.
number 39. Going to withdraw the.
Serial number?
bylaw. Serial number 39.
What do you want?
I'm going to withdraw the appeal. Since
39.
liberty.
I read appeal number 1755 of 24, learned advocate Mr. So and so, places on record, memo dated 4/12/24, seeking to withdraw the writ appeal. The memo reads as under, quote the memo. In view of the above, permission to withdraw the appeal is granted, dismissed as withdrawn.
Obliged.
You have settled it.
No, my lord, I have filed a writ petition.
Writ petition.
Serial number
Dismissed as withdrawn without expressing anything on the merits of the case.
serial number 109, my lords. I requested for tomorrow.
Was, one second, this was 38 or 39? 39, yes.
Serial number 109, your lordship.
109, somebody mentioned?
Please, my lords.
Ah, yes, so what do you want?
My lords, I appear for the petitioner, my lords, in the matter.
Yes.
This was a matter, my lords, moved a writ appeal being filed, my lords, without the certified copy being available, my lords, due to the.
You want to take up?
My only request, my lords, I am not in station tomorrow morning, my lords, if you lords. The next exam is day after tomorrow, my lords.
Day after tomorrow, day after
Is the
tomorrow,
next-
11, at
Day
11.
after
we'll take
tomorrow, yes, my lords, another exam is scheduled. Tomorrow, my lords, may I request your lordships? I'll come physically, my lords, to make my submissions. I'm placing the certified copy before your lordships today.
All right, tomorrow, take chance.
Grateful, my lords. Grateful.
Certificate copies.
Certified copy, my lords, I'll hand over, my lords, to the court officer.
Serial number 135, filed memo for withdrawal. 135.
135.
What is it?
135?
Yes, my lord.
Yes, what is that?
Memo for withdrawal in view of the registry has raised the objection.
Memo
In
for?
view of ILR 2009 Karnataka 1207, appeal is not maintainable.
What is the request? What is the request, sir?
Withdrawal method, can be
Not able to get what we are.
not pressed, my lord.
You want to withdraw?
Yes, my lord.
Like, memo is filed?
Filed memo. Silva.
Learn, this is on 135, learn, contempt petition 126 to 24. You Raghavendra Gayatri.
Namdo. Sorry, my lord, my appeal is 134.
134.
Serial number 134.
134. You are Mr. Arvind Sharma?
Yes, my
Learned advocate Mr. Arvind Sharma, read appeal number 1157. Read appeal. Arvind Sharma files memo. Invite settles number court 2. Memo dated 22/10/24, already figuring on the record of the appeal. without expressing anything on the merits of the contents of the memo as well as on the merits of the controversy in the writ appeal, the permission to withdraw is granted at the risk and consequence of the appellant. Disposed of as not rest as above. At the risk and consequence. At the risk and consequence. लिखा ना? 90. Reverse में ला 90 then whatever. Yes, Mr.
Serial number
What is that?
90.
90. What is it about?
But they have not paid the amount, madam. Hello. Maintenance amount has not been paid, madam.
So you are for respondent?
Yes, madam. Respondent.
As per law, as per direction of this honorable court, 10,000 per month I am paying since last 15
Where-
years.
Where are the directions?
Direction is your lordship, the appeal, the contempt petition, you may refer
Point
page,
out his position. Where is the
page
direction?
83.
Pardon, my lord.
Point out the direction.
My
You
lord,
are the petitioner.
the lordship gets at page number 77, my lord, the order. Criminal revision
77.
petition. Yeah. Relevant portion is at page 82, my lord. Paragraph 6, my lord. Married, my lord.
What direction is?
Page,
To pay, my lord, 2,500 rupees was ordered in the trial court, my lord.
2,000
Fine,
per month. to
per
the
month,
respondent.
under DV Act.
Further directed not to evict the respondent without the due process. Further to pay the sum of 5,000 to litigation.
your lordship,
It is paid or not?
It has not been paid.
page 69 of the contempt petition,
Page 69.
order of this honorable court.
Page 60.
Page 69. Running page 69 of contempt petition.
Yes.
Para 9, your Honor.
Yes.
It is clarified that the maintenance order in the present proceeding shall include maintenance, if any, granted in the proceedings under Domestic Violence Act 2005 or any other proceedings. According to this order,
Yes.
we have not considered what she is doing it, that before this order, what amount is available, she is claiming 50,000. She is not claiming all, saying that order is not applicable, earlier past order.
So then this
That's
order,
all the point.
this order which is brought under contempt is subsequent to this order.
Yeah, that's what her presentation is said very
No, no,
clearly,
the order-
granted, granted, past tense, your lordship. I have made a submission.
The order you are pointing out is dated 8/1/8/16.
16, my lord.
Passed in MFA number 3407/16.
Please, my lord.
Which says that it is clarified that the maintenance order in the present proceeding shall include maintenance,
Passed in the year
if any.
2016.
Hmm?
2006, order is dated, yeah, 2006.
On that day, this order was not there. On that day, when this observation was made, the order under the Domestic Violence Act was not passed, which is that page, which is the under contempt now.
Please.
Yes, your lordship, the order is granted, I make a submission. The 2,500 is also granted by that, the order should include this year. And that the order been passed.
How can it include a future order?
No, that is what the order is very clear, your lordship, what I understand it. It is clarified that the maintenance order in the present proceeding shall include maintenance, if any, granted in the proceedings under
On
domestic.
that day it was granted? If any, it was granted on 16, it was granted. The order of granting.
Another point, Your Lordship. The matter was sub judice. She has filed that application for recovery of money was pending
Can
before
you
the,
take clarification from learn a single judge?
pending before the,
Not single judge, it is division bench.
Chief Judicial Magistrate.
That
That was pending there for the same consideration.
Seek a clarificatory application. Clarify, get.
What I am appreciating the law, I have submitted.
So we are saying that please
I
get.
am appreciating what the law is, that that money is included in this, my maintenance of 10,000 rupees.
How can it be included?
2016. This was ordered. This is after that.
No, Your Lordship, that order was earlier,
That's what.
not after that.
That is the.
2014, that order was, my order has come on 2016. 2014 was the magistrate order.
No, this order of 2,500 is of which date?
2014, the order was passed by the chief judicial magistrate. And in that proceeding of domestic proceeding.
What was the order? What was that order? On that day, order was passed. On that day, order was already there. Somebody will ask to ask this.
Just tell me.
You can ask it. Please ask it. Thank you.
He's asking whether the order.
Mister, just we want to know.
Earlier or.
Earlier, Your Lordship, 2 years earlier.
It was earlier.
My order passed for this order passed
And
by
that order is confirmed.
2016. The chief magistrate, judicial magistrate order was 2014. That's the 2 years she is asking. That's all.
You are right.
50, sir.
You are right.
That isn't.
That original order which is confirmed by the division bench was in 2014.
14.
And in 16, the order was passed that the amount granted in that order will include the amount granted in 14 order.
And Your Lordship, she been proceeding before the chief judicial matter was filed, it was sub judice. I have not committed any fault. I have not committed any
Lord
fault.
learned advocate, Mr. So and so for the petitioner complainant and learned advocate, your senior advocate.
Exemplary cost may be given to my client.
No.
Your Honor.
Senior and learn. Senior advocate. And learned advocate, so and so, the respondent. The contempt is alleged in respect of non-compliance of order dated on the 5th April 2023, passed by the division bench while dismissing the criminal division petition number 1197 of 16. In the said criminal division proceedings, the challenge was made by the husband, which was directed against order dated 22/11/2014, passed in CM miscellaneous number 75/210 of the criminal miscellaneous application number 75/210 by the Chief Judicial Magistrate, Bangalore, Rural District, as well as order dated 18/8/16, passed in criminal appeal number 82 of 14, whereby the order dated 22/11/14 was confirmed. Full stop. The division bench upheld the said orders. Paragraph. As per the order upheld dated 22/11/14, the husband was to pay sum of rupees 2,500 as maintenance per month. It was an order passed under the provisions of the section 12 of the Protection of Women from Domestic Violence Act 2005, as per which the aforesaid amount of this 200 2,500 was quantified as the maintenance to be paid with ₹5,000 towards litigation expenses. Full stop. It is to be noticed. It is a fact emerging from record, as was rightly pointed out by learned advocate for the respondent husband. You are respondent wife?
Husband.
Respondent. Respondent husband. Yes, that in the proceedings of
Proceedings which the Honorable High Court has given you the protection. Page number.
69.
69.
Page number 69.
Yes, in the proceedings of MFA number 3407 of 16. Which was by whom? Which was, that proceedings was by whom?
I preferred it yourself.
By the husband. From order dated 1/8/16 was passed by this court. It is by this court.
Was the order passed by this court?
By
this court.
this court, the
Whereby
decision
it
bench,
is-
your lordship.
whereby the interim order, whereby interim order was passed, directing that the maintenance which was ordered by the family court at ₹7,500 per month shall continue to be paid by the respondent from the date of the judgment of the family court on regular basis. In that order, it was clarified as under then court paragraph 9. Thus, when the order was passed by learned Chief Judicial Magistrate dated 22/11/2014, thus the aforesaid order was passed after the order dated 22/11/14 passed by Chief Judicial Magistrate granting ₹2,500 as maintenance under the Protection of Women from Domestic Violence Act 2005, which was confirmed by this court. Full stop. As per the above clarification, the amount granted under order dated 1/8/16 would include the amount of ₹2,500 granted as per order dated 22/11/14 in respect of which the contempt is alleged. Therefore, it cannot be said from any stretch of imagination that that any contempt is committed by the respondent, since the amount of 2,500 was included in the earlier amount granted as per the clarification. Dismissed.
Your lordship,
Petition is-
cost maybe, yes,
In contempt, no cost.
so much of money my client have spent.
Maybe.
Oblige you.
Is serial number 110.
$110.
Number 110. To Judge Anthony Cruz.
No. No, take up the 230 matter.
1 week now. 1 week.
Yes.
1 week.
Yes. Yes, sir.
Appraise for 1 week time. आप इस subject का.
1 week time.
Yes.
You file memo of withdrawal.
Consent to party. Some documents is not available.
But you file memo of withdrawal. Yeah. After vacation. 21st January as requested.
Yes. Number 71.
Here for the petitioner, Lord, in the morning, the learned senior counsel had mentioned this. My learned senior is on his legs in another court. The matter may be taken up after the 230 list, my lord. Subject to the convenience of this court, can it be taken after the 230 list? Learned senior counsel, Mr. Dylan Rao is on his legs in another court.
Then day after, so that other matters can reach.
Please,
So granted you the liberty for priority, but if you are not available for some good or other reason, day after tomorrow.
please, my lord, there's an interim order.
It will be extended if there is that.
Grateful.
Next.
It's number 49. Number 49.
Yeah, I'm for the petitioner, my lord.
What is it, 49?
My-
Contempt?
My lord, contempt, the honorable single judge that passed the order against the VWSSP to provide the facilities for the drinking water as well as sanitary facilities. But we were given the time also to approach. We approached several times, which is on page number 24 and 25, Your Honor. The letter written by the residents of the association requesting to implement these orders of the honorable single judge. Till date, they have not done anything. And subsequently, the whole area is completely full of drainage water left out of this one. This is 122 apartments. Around 500 people are staying in this apartment. There are small school-going children and aged persons, senior citizens. They are having all health and hygienic problem.
No, that is right, but they have, they have done, they have not complied with which part of the direction?
Which part of the, Your Honor, this is on page
16.
Page 16. This 35, I will read it out. Order, the writ petition are allowed in part. The demand of advance probable pro rata charges and treated water charges for construction upheld. The demand of beneficiary capital contribution charges and greater Bangalore water sewage project charges are held to be illegal. This is where exactly we are facing the problem. They have disconnected the line only about a year back. Then we filed the writ petition for this. Till date, they have not connected that drainage water. And I have produced the photographs, Your Honor. Sorry, don't do. Photographs I urgent hearing. I have produced the photographs, my lordship. If you can see the drainage water entering the building, the entire road, the photographs are available. Which shows this is before rain, 3 days back. And they're facing a horrible situation actually. All elderly people, this is going on from last 1 year, they're suffering actually. We have paid all the fees to the builder as well as to the Bangalore Water Supply Board.
You may be right, but where is the direction to reconnect the?
That is what exactly, no. Now they told to approach the single judge, honorable single judge to approach within 8 weeks. We approached. Personally also went, all the association members. They went and met the concerned works engineer of the area, as well as the chief engineer. But till date, they have not connected the sanitary. The whole area, my lord, if you can see the photographs, entire area of the stretch around 300 meters, is flooded with this water, drainage water. And with this raining, it is completely shattered actually, the entire area. Even the school buses cannot enter. That is the situation we are facing. There are 500 people, 122 apartments. And till date,
who will appear? There is no direction, mister. This is a contempt proceeding. Unless there is a positive direction, there is no contempt. We understand your submission that this is beneficiary capital contribution.
this order has been violated, my lord.
What is violated?
This order is that sewage connections has to be restored.
Where is that?
It is here on page number 3, I for an order. The demand for beneficiary contribution charges and greater Bangalore water sewage project charges are held to be illegal. They have demanded this sewage charges, which is illegal.
Correct.
What we are asking, and may I read it out another, if you permit me, my lord. The obliteration as found in clause 3, Supra will not come in the way of the state or the board to bring the charges that are held to be illegal under the provisions of the Act or the rules by making suitable amendment to the Act, rules or the regulations.
What do you want? Sewerage to be reconnected.
Sewerage to be connected and drinking water facilities to be provided, which is a basic necessity, my lord.
Is that?
And also against the builder, the Honorable State Commission has passed the order also to provide, refund the amount and to provide the, this money to the VWSSP to get the drinking water facilities. Direction might be given to BWSSP to implement the order of the single judge. My lord, there are seniors who have come here also. See that if you listen to them, if you permit me, the agony they are undergoing day in, day out. They're all retired people are there.
Who will appear?
DL Sanjeev appears, I think, BWSSP.
There is a dispute between the owner and the builder. That is before the state commission. This honorable court directed them to go before the state commission. Now it is pending there.
No, I'm sorry. Already I've submitted the orders of the Honorable State Commission, which is in our favor.
The builder has to pay the amount. They have not paid the amount.
No.
What he says is,
Your Honor, we have deposited the money earlier, Betrainpura Town Municipal Corporation. Now they are telling, BWSSP is telling that you have paid to Betrainpura Town Municipal Corporation, not to BWSSP. We have produced the deposit receipts also.
Your remedy is not a contempt. Your remedy is
At
to.
least direction I am seeking, Your Honor.
How can we give a direction? This is not a writ of mandamus.
And also,
In contempt, you are seasoned advocate.
what my friend is telling,
You are very much seasoned advocate. This is contempt jurisdiction.
while disposing also the
For
honorable court,
exercising contempt, there must be a direction,
nothing.
clear direction, positive direction.
No,
We can't read into, we
No,
can't
this-
add, we can't modify. We can
the
interpret.
order has been violated by the BWSSP.
Which order, sir?
This is the order which I read it out,
So by not reconnecting the,
reconnecting the sanitary.
Where
That
is
is a
that?
major issue.
where is that direction? That requires a writ of mandamus.
No, no.
Not the contempt.
Our prayer in the writ petition itself is to restore the connection to the sanitary. That is what our prayer also in the writ petition. That our IA, which has been presented before the single judge, was the same thing.
But it is not granted. The writ petition is disposed of in the very same findings and observations.
That was
These are
not-
the observations.
Writ petition has not been challenged. It has not been challenged.
No, this writ petition is in our favor. You have to challenge.
Not-
Not, we cannot challenge this writ petition. My humble submission, Your Honor, we have deposited the amount to earlier Betrainpura. That is what exactly it says also. Beneficiary contribution.
You go immediately draft 226 petition and file.
Your Honor, 226 already we did that. Again, we have gone to State Commission also. There they have ordered to refund the amount also. My humble request.
Or you can go before learn a single judge for clarification. Choice is yours.
No, my humble submission, my lord, is that a direction or a notice to be given. We are ready to get that sanitary. No, sanitary connection. If you look at these photographs, Your Honor, it is so horrible actually in that area.
Well, this is contempt jurisdiction. There is no direction to be complied with. Or contempt can be said to have been committed. There is no direction.
No,
This is not a writ jurisdiction.
no, some advisory notice or something, because it is humanly impossible the place where we are going to stay there.
This is court of law. We are bound by.
No,
the
this
jurisdiction.
order has been violated by
Which order?
BWSSP.
Tell us which direction is violated.
That is, they have disconnected the sanitary line
Where is
itself,
that direction if it is violated?
which is illegal, they say in the order sheet, it says it
That's
is
all.
illegal.
That's all. Consequential is not provided. Consequences are not provided. For that, you need a writ of mandamus. And that is not the domain of the contempt jurisdiction at all. So choose your course of action, or we pass the order now.
May I take a minute, my lord? My lord, in this, I go to page 15. Heard Srimati Bhavana Nandana Patil, learned counsel petitioner, B.L. Sanjeev, learned counsel for respondent. The charges levied against the petitioner in the case at hand are few, are all the charges, namely beneficiary capital, contribution charges, Greater Bangalore water sewage project charges, advance probable pro rata charges, or treated water charges construction. These very charges were considered by this court. Your Honor, my lord, this is because we have not paid this charge, that is why they have disconnected. But we have already paid. And it says within 8 weeks, you approach directly the Bangalore Water Supply Board. We have approached it within 8 weeks.
Finally, we are not inclined to. What is your choice?
My prayer is at least direct them to provide, no, at least a notice and seek the clarification on this order actually.
There is no direction which can be said to have been committed contempt of. So therefore, contempt jurisdiction is not attracted. Your remedy is elsewhere. And though we are not in advisory jurisdiction, we have told you what is the remedy. Nothing more now.
My lord, as far as the builder is concerned, already matter has been sorted out before the State Commission consumer.
We are not concerned with State Commission. You are a fairly seasoned.
No.
You are a seasoned, experienced counsel. You know what it is.
No, a direction to the Bangalore Water Supply.
It can't be given in contempt jurisdiction.
Some kind of advisor, at least because the human beings are staying in very. You have appeared for a BWSSP, that can be considered. Your Honor, it is a.
If he is ready to consider, we are ready to adjourn.
No. In fact, my lord, the honorable judge said, why don't you go and make some representation with the builder? They did not go.
No. Builder is nothing to do with the already order has been made. Builder to refund the money. That money we are remitting to the BWSSP. My lord, the contention is, if my humble submission is, contention is that you have paid money to Batrayanpura Development Municipal Corporation, not to BWSSP. But that funds has gone back to BWSSP only.
It's a very good argument, but in that jurisdiction, not in contempt jurisdiction.
Some kind of an order or relief can be passed, I think, sir. Because this is the highest court, I am sure that some kind of relief can be sought. It is becoming highly impossible to live day-to-day basis. That is why we are approaching with an urgent hearing, my lord.
We have our own discipline. What do you want now? You file a petition or we pass the order? Inviting order or withdrawing to file a petition or whatever recourse you have?
We'll file the petition.
Learned advocate, after some amount of submission, seeks permission to withdraw the present contempt proceedings, seeking the liberty to file appropriate proceedings with regard to his grievance that the sewage connection is not, sewage is not reconnected by the authorities. Without expressing anything on merits, this petition is permitted to be withdrawn and disposed of accordingly.
My lord, out of the way, one small submission, you can guide them at least that area. It's not connect, clear this, at least as an advocate, counsel of the BWS, that area is really stinking. You cannot even walk. At least that can be considered to clear the area.
All this was told to my learned friend. Even I told him to go there. He did not even meet the engineer.
My lord, 100 people have gone. They are here. They are out of that association. People are here. They have gone several times. Photographs are there.
So tell them.
At least that can be considered.
Representation considered.
Much obliged.
So Vasant Kumar HT, seal number 10, contempt.
What is it? None was present in both the calls in that view. 10th to 9th of January.
Seal number 1, Mr. R.G. Egde.
Serial number 1 of second.
But I'm sorry, I was not present when the case is called in
matter.
morning.
Regarding
this is third or fourth time the complainants approach this honorable court. Ultimately, a direction is given, page 22. Mandamus issues to respondent number 4 and 5 to upload the caste certificate on the web portal and make the caste certificate accessible to the petitioners forthwith.
Notice returnable on. Notice returnable on which date? For the time being 7th January?
Yes. They are not giving the certificate at all.
Thanks to my brother, otherwise I would. Yes.
Number 135. Raghavendra G. Gayatri.
Okay for the petition.
In this matter, my lords, we have preferred a writ appeal. Lords, we have almost complied with the objections. Your lordship may kindly tag along with the writ appeal, my lords. Writ appeal number 1774 of 24.
We listed with writ appeal number 1774 of 24, which arises out of the same order brought under contempt.
Lords, if I may, my lords, may I seek for a date because it's still in compliance. Their intra-court appeal is still in compliance.
Lords, we have
Otherwise that-
complied, my lords, to major of the objections. A week after a date may be given. Only some translation is pending, my lords. Next week date
Observe
may be.
that the appropriate order shall be obtained in the writ appeal by the authorities within 8 weeks.
Obliged.
If that is not done, Mister, you can pursue your contempt.
Lords, nevertheless, it may be tagged along with the writ appeal, my lord.
It is done.
Please,
But nonetheless, you have to.
please, my lords.
Number 136. Mr. Jnanesh Kumar K.
Lords, in this matter, we have issued a government order, my lords, admitting the complainant into the grantee aid.
My lordship, monetary benefit is pending, my lordship. I have not complied. Monetary benefits is pending, my lordship. Appointment order is issued, my lordship. Kindly
Yes,
page
the
number 10,
only
my lordship.
order is to admit to grantee aid, which we have complied, my
Page
lords.
number 10, my lordship. Para number 4. Concerned state respondent is hereby directed to pass a speaking order in approving the petition's appointment within a period of 8 weeks from the date of receipt of this
Yes,
order.
we have done that, my
And
lord.
consequently, monetary benefits shall also be extended to the petitioner. Not complied. To the extent of monetary benefits, my lordship. Not complied to the extent of monetary benefits, my lordship.
To the extent of,
Monetary benefits.
where is that?
Page number 10, my lord.
Where is the monetary benefits?
Page number 10 in para number 4, my lord.
Page number
10, my lord.
10.
Yes, my lord. Para 4, my lord.
Which order is under contempt? Oh. So
Para
page-
number 4, my lord.
Page 10 is the order under contempt.
Order of writ petition, my lord.
Page 10. But then this is barred by limitation. Mister.
No, my lordship. No,
Which is the order under contempt?
Lords, may-
after
Page 26 of the petition.
26 of the petition. 26 of the petition.
The previous page, 6 on, para 6 on.
in writ appeal is dismissed, my lordship.
Confirms the order of learned single. So directions are issued about
Grantee aid, to be admitted to grantee aid, which we have done.
monetary benefit.
Yes.
It is there, page 10. Page 10, paragraph 4, last 3 lines.
We have partly complied by a admitting him to grantee aid, my lords, then some time may be granted
It's
to.
also substantial part. Shall we dispose of-
Substantially, we
No, my lordship, keep pending, my lordship.
by directing them to pay within 8 weeks.
Please.
Otherwise,
Manoj.
suppose, no, I am not sure, my lordship.
We are sure that.
Yeah, no.
By judgment and order dated 23rd November 2023, the coordinate bench of this court dismissed the writ appeal number 184 of 22, confirming the judgment and order of learned single judge dated learned single judge in writ petition number 23246 of 23246-247 of 2016.
Shall be complete.
246 of 16. 23246 of 16. The direction the court was to admit appointment to the petitioner for the purpose of grant in aid and to pay the consequential monetary benefits. When these contempt proceedings come up for consideration for the alleging non-compliance of the orders of the court from a learned additional government advocate submitted that the post of the petitioner has been admitted for the purpose of grant in aid. She submitted that to that extent the order is complied with. Learned advocate of petitioner would submit that the part of the payment of the consequential benefits is yet to be complied with. Full stop. In the aforesaid view, the court is inclined to close the present contempt proceedings by directing that the monetary benefits which may arise for the petitioner pursuant to his post having been admitted to grant in aid purpose shall be paid to the petitioner within 8 weeks from today, failing which the respondent shall be exposed to contempt proceedings again.
Yes, my lordship, at least they failed to comply the order within 8 weeks. So some cost may be imposed at least, my lordship. Otherwise, I will not. That is the main issue, my lordship. Otherwise, I will be constrained to file one more contempt petition, my lordship.
To file petition for cost.
Number 137, 137, Mr. Srinivas K.
Hearing complaint, my lord.
Complied and an affidavit is
That is
filed on.
complied, my lord.
Complied with. Learned advocate Miss so-and-so.
21st affidavit is placed on record.
That the order is complied with. The statement about the compliance is confirmed by learned advocate so-and-so, so-and-so, the respondent. In view of the above position obtaining, nothing survives in the present proceedings. The petition is
138.
138 also same order.
Has not
138
survived.
also same order.
Which is same order?
Yes, my lord.
138.
138 same order. Thank you.
Much obliged, my lord.
Number 139,
Appear for the complainant.
B.S. Nagaraj.
But I'm
That's in this matter.
prepared to withdraw this petition with liberty to file a petition challenging the order. Passed by the-
Learned advocate Mr. B.S. Nagaraj files a memo. Memo? Memo.
With liberty to file a press
Seeking to
petition.
withdraw the present contempt proceedings. Stating further, memo dated 4/12/24, seeking to withdraw the present contempt petition. Further, however, seeking liberty to file press petition challenging the order dated 15/11/24, passed by respondent 2. That's the Assistant Commissioner Pandavapura. Full stop. Since the order is complied with, the contempt petition is disposed of as not surviving. Liberty paragraph is reserved for the petitioner to institute appropriate independent proceedings to challenge on merits, if aggrieved, order dated 15/11/24, in respect of which, however, this court does not express any opinion On merits.
Similar, 140.
Lords, I beg to appear in 140.3. Lords, a suggestion was made by the learned Advocate General on the last occasion that, my lords, since the appeals are against an interim order, the learned
Yes.
civil judge could be requested, my lords, to
Learned AG is on his legs, my lord, in the other court. He would make the submission.
Day after.
my lords, I'm just
My lord, he's
making
on his legs in another court, my lord, Learned AG.
So day after.
Very well.
Day after at 2:30.
Please.
Sir, Gauri Shankar, party in person. I want to make a small submission, my lord. Here, sir, front of you. I want to make a submission. Will I have 1 minute, sir?
Yes.
My lords, may I complete my submission, lord, subject to your lordship's leave?
But what is to be done? This order to, the all orders to continue and learn a single judge direct.
Yes, my lords, I am in agreement with the suggestion made. I had taken some time to seek instructions.
Correct.
Your lordships may be pleased to dispose the appeal, continuing the interim orders that are operating in all appeals, keeping open the contentions and requesting the learned single judge to decide the main writ petitions as early as convenient. That was the suggestion from the state as well. So we are on, we have some consensus.
So shall we dispose of or shall we wait?
AG wants to make some submission, my lord.
AG wants to make submission, then day after tomorrow at 2:30.
As your lords, the interim order may kindly be continued.
Interim order
Lords
shall-
appearing for the union, would
And
your lordships
also-
kindly have it on Tuesday?
Huh?
ASG has some difficulty on Friday, my lords. Would your lordships kindly have it on Tuesday?
This is a formal burial of the matter.
Yes. You would like to make some
Not
submissions.
formal, decent burial. Anyway, 9.
Yes, grateful, my lords.
Please. Interim orders to kindly.
Interim order shall continue.
Grateful.
Your lordships have it on 10th, my lords.
Sorry.
How long this will live? 10.
Sir, part
Grateful,
four,
my lords.
sir, part 4 of this matter is a public interest litigation. Last time I requested for delinking the matter. You told me that.
On that day, if required, we delink it.
Okay, sir.
We'll examine whether it requires to be delinked.
Thank you, sir.
These 2 8 matters.
Next to contempt, Karnataka. Faster.
List number 2. Still number 1. From Balraj AC.
So 10.
Sweep.
Fast.
Still number 2. Mr. Adinaranappa.
Here, complaint.
Still number 3. Mr. Ashwath Narayan.
Please, my lordship. We appear for complainant.
Complied with?
Complainant,
Order is complied with?
complaint. Please, my lordship. Our complainant employs service in BBMP. The third. To release the High Court order, page 10, second page, my lordship. To release the salary from 27/7/2018 to 11/7/2019 on the pay scale of executive engineer and treated as compulsory waiting period under Rule 815F KCSR rules and consider in the representation dated 5/8/2021 vide Annexure G. The employee's waiting period salary, my lord, 1 year salary is paid to BBMP, Chief Commissioner, my lord. We get a High Court order and submit before the authority, but they are not consider and obey the High Court order. Then we filed the contempt petition before the court. We are a complainant employee is retired on 2020, my lord. The employee and family members are suffering, no pension and no salary, 1 year salary is due. The respondent, Chief Commissioner of BBMP, is released the 1 year salary, my lord. Please initiate the contempt proceedings that initiate.
Directions are at page 14, my lords.
You got the reply filed by them?
Perhaps we have served it. It's been served.
Have you got the reply filed by them?
They filed and all the things are discussed and order in writ petition, my lord. We get writ petition order and submit the authority. They are not settled our salary, my lord. 1 year salary is due. We are retired and now we are suffering, waiting for the salary, due salary, my lord. Please insert the contempt order. The respondent to Chief Commissioner is responsible and settle our salary.
What is the direction?
Yes, direction. Oh, the order portion we read, my lord. This exercise shall be completed within a period of 8 weeks from the date of receipt of certified copy this order.
What exercise?
8 week time given to court to the Chief Commissioner employee, government, they are not, now 8 months are passed, we are not get a shot.
What exercise was to be completed?
8 weeks
What exercise? What kind of exercise?
completed within a period of 8 weeks.
You be, prepare yourself. Prepare yourself. Then come. Mr. Representation is already decided.
We give representation also,
It
order
is-
with the representation to the,
It is decided.
yes, my lord.
So contempt, there is no contempt.
So we filed contempt petition before.
There is no contempt since representation was directed to be decided, it is decided. Right?
Yes.
Heard learned advocate Mrs. So-and-so and learned additional government advocate Miss Pramod indication, full stop. Respondent on state in order dated 22nd February 24, passed by learned single judge while disposing of the writ petition, respondent one state was directed to consider the representation of the petitioner dated 5/8/21 and pass appropriate orders by taking note of the judgment of the coordinate bench. Full stop. In response to the notice issued by the court in the present proceedings, our respondent have filed the compliance affidavit along with which an endorsement is produced. As per the said full stop, as per the said endorsement dated, no date. 29/8/20. Previous. 29/8/24, the representation of petitioner is rejected in view of above decision on the representation, deciding the representation. The directions are complied with, therefore contempt proceeding does not survive. It is accordingly disposed of. Paragraph, however, it is observed that if the petitioner has any grievance on merits about the said endorsement dated 29/8/24, it will be open for the petitioner to institute appropriate independent proceedings to challenge the same, in respect of merit of which, however, this court does not express any opinion.
Number 4, Ranganath R.
This was which? Item 3 and all. Next.
Number 4, Mr. Ranganath R.
10.
Number 5, Mr. Vinod Kumar K.
10.
Number 6, Mr. Srimati Manjula Devi. Number 6.
10.
7 disposed. Number 8, to Govindraj K.
Appear for the complainant, my lords. I have filed Wakala. My lords, your lordship may kindly see the order of which implementation is sought for is at
Annexure A, page 10. And the direction is at page 13. Lords, the petitioners were seeking for regularization of service. And this court held that they have to be regularized in terms of the directions in WP 3672 of 2021. 3672 of 2021, my lords, is annexure D, page 26. In similar matters, my lords, they had issued very similar endorsement. And this honorable court has come heavily upon the authorities for issuing
So
such an
what
endorsement.
is the direction here?
My lords, the direction is
Consider the case of the petitioners in accordance with law in light of the order passed by this court. Where is that order?
that 3672, my lords, your lordship will
Yes,
get
yes.
annexure D,
Right. Where is 3672 order?
annexure D, page 20. I'm sorry, 26, my lords, page 26.
Deemed regular.
My lords,
Yes,
It's,
one
my
matter was there.
same, my lords, similar endorsement also. One matter, your lordship came down heavily upon them for issuing similar kind of endorsement.
That's corporation has to.
5.1 and 5.2, my lords.
10, 12.
The said endorsement dated 6/9/2024 in the last paragraph reads as under. In view of the directions of the Honorable High Court in WP number so and so, and also as per the government circular, your request have been examined since you have been appointed as daily wage employee after 1/1/1986. There is no provision in the rules to
That's the
regularize your service
Matter is
That's-
listed on 10th, my lords, writ
for
appeal.
complaints. Even in this, they are saying, though they have.
May be listed on 10th, my lords. I request for adjournment.
But
In similar set of facts and circumstances, order was passed by this court in CCC number 819 of 24. Denouncing the approach and conduct of the authorities in not implementing the identical kind of direction, whereby the regularization is granted to the petitioners on deemed basis. The petitioners are therefore required to be treated as regularized. Full stop. Since the other contempt petition is coming over 10th of December, this shall also be placed on 10th of December along with the said CCCC number 819 of 24. Full stop. On that day, learned counsel for the respondent shall ensure the court about the shall apprise the court about the steps which may be taken for compliance.
Number 9.
We have to come, you explain to your officer what is deemed.
Your lordship has made observations, my lords, that about the audacity in passing endorsement
Yeah.
against the finding of this honorable court. Still, it appears nothing has moved them.
Number 9. Sir Umar E. Farooq.
10.
Number 8, my lords, can my name be shown, my lords? I have filed wakalat in the place of Mr. Govind Raj.
8 में लिखना. Learned advocate responsive states that he has filed wakalatnama in place of the advocate presently on record for the petitioner. In that view, the registry will verify, and if the wakalatnama is filed, the name shall be mentioned.
Great.
While notifying the petition on the next date.
That's deeply obeyed.
List 1, number 35. The Narayan Swami D.
This petition is filed praying for set aside the order passed by the learned single judge. Wherein the forfeiture of the EMD amount has been ordered to directed to pay to the defaulted bidder, my lord. The petitioner is the
Not
house.
yet written amount.
In fact, that is that order is quite contrary to the order passed by this honorable court in the recent judgment, my lord. It is covered. I prayed to set aside the order passed by the learned single judge, wherein I was directed to repay the forfeited EMD amount, my lord, wherein the respondent participated in the sale proceedings undertaken to participate in the sale proceeding. In between, after he submitting the bid amount and paying the initial amount, he didn't turn to comply the remaining proceedings, my lord. Therefore,
Under what rate you are retaining the amount?
there is an undertaking under rule 9(5). He is supposed to comply all the terms and conditions agreed under the bid form as well as the undertaking he submitted on 19th August 2022, my lord. Thereafter, sale was taken place on 10th September 2022. Even after repeated requests, he didn't turn. And finally, he sent a request stating that refund the EMD amount, for which on 21st December 2022, I told that it has been already forfeited and under the terms and conditions, bid form as well as the sale terms, my lord. That has been challenged before the learned single judge. That has been, that writ petition would not be entertained because of the efficacious remedy is available to the aggrieved person before the DRT, wherein the writ petition was filed. And writ petition is allowed in terms of the submissions made by the petitioner, here the respondent, and directed me to refund the forfeited amount, my lord. That has been challenged here. Why? Because in the recent past, this honorable court itself passed in a judgment wherein it is squarely applicable to the matters, my lord. I may be 16th October, in the identical matter, this honorable court passed, and that the similar judgment has been set aside, my lord. The facts and circumstances of the present petition also applicable to the same the judgment which this honorable court passed on 16th October 2024, my lord.
Here he did not participate.
My lord.
So auction was not held at all. Auction was not held.
He has been declared as a successful bidder. And 10th, the respondent.
Only one bidder.
Yes, my lord. Thereafter, up to December, he never turned with the request of the petitioner. Thereafter, he sends a mail stating that refund my amount. In fact, actually, on 21st December 2022, I replied stating that since you are not complied with the terms and agreed terms and conditions of the sale proceeds, therefore the EMD amount has been forfeited. That communication has been challenged in the writ petition, wherein that has been passed, my lord, and passed the order directing me to refund the EMD amount. Against that order, I filed the present appeal, praying to set aside the order passed with the learned single.
12th we are keeping. 12th.
I filed stay of the operation of the.
Let us say we have not made up our mind either. On 12th we'll take it. Come on 12th. 12th of December.
Much.
At 2:30.
December 36, the Krishna R.
The effect to the appellant. But on 28/11/24, this honorable court had adjourned the matter to 23/1/2025, my lord. Since the workman filed a complaint before the judicial magistrate for non-compliance of the award, matter was again moved by this before this honorable court, and that is how matter has been listed. Lord, this writ petition has been filed by the appellant challenging the labor court award, by which the labor court directed the appellant to reinstate the respondent back into service with 50% of the back wages. And the labor court award was stayed, and I am paying 17B wages. In the meanwhile, the writ petition was posted for final hearing. The matter was dismissed for non-prosecution on 22/24, page 18.
For a notice written in February. Somewhere in February 28.
Next.
Issued notice.
Yes.
Number 37. Stadium.
37, senior is held up in other.
Then it will go in January.
Tomorrow, my lord.
Not possible.
Some urgency is there.
What urgency?
Similar matter already my lord has stayed. Common order by passed by the single judge.
What is the urgency, sir?
Proceedings before the industrial tribunals are going on.
It is the subject matter, not the urgency.
That's the my lords, because the issue with respect to my lord's constitutional validity of two notifications passed.
Then there is no urgency.
My lords,
22nd January.
this 12th
Not
of-
possible tomorrow.
12th of December.
Not possible tomorrow.
Difficult is senior is held up. my lord.
Maybe, but we are not dismissing the petition. Tomorrow is not possible. That is what at all we are saying.
12th of this.
Pardon?
This month, some other day. Any day.
19th of December,
Acho.
20th December.
Yes.
Number 38, Rajeshwar PN.
For the appellants.
For respondent number 1, my lord.
The other writ appeals, my lords have heard and fixed the date on 11th.
11.
Common order. This appeal may also be called along with those two appeals.
Which is that appeal?
Writ appeal 1691 of 24.
All right. Which date? Keep it wherever the council wants. Till 38. All right.
The commercial appeals, serial number 40,
Malats, in this matter,
A.
notice,
Gopi Krishna.
notice, notice may be issued. Other matters also notices.
Which matter?
The connected matters, Malats, it's coming upon 11th, notice is issued in those matters.
Hold it. So what
I am
notice?
for appellant, my lord.
What do you want? This, you want some particular day?
May also be called along with those matters, Malats.
That is what we have done, to be listed with,
Number 40,
Yes,
To
I
be
am for
listed with-
uh,
appellant, my lord.
on 10th,
Sorry.
11th.
11th.
Appellant, my lord. The matter is related to suit for injunction and rest,
sorry,
specific performance of the contract, my lord. My lord, appellant is a tenant under the respondent, my lord.
Notice returnable on January 9. Next.
number 41. It's a miscellaneous first appeal, arbitration. Appellant,
Whereas I appear for the appellant with Mr. Mithun, my lords. Whereas here we have, the appeal is against an order of the district court which upholds an award against us. So we filed our appeal, my lords. The urgency is that there's a stay application we've taken out. The urgency is that the execution is coming up on the 19th. I'll tell my lords what has happened. Plus, there was a joint development agreement, and under that joint development agreement, there was a great delay in the construction. It's my own property. He's the developer. We got into this joint development agreement. He constructed it, but after a great delay. Instead of 3 years, he's taken 10 years. My claims were there for damages. None of those claims have been allowed by the arbitrator. Their counter claims for some security deposit, etc., has been allowed. Now, my lords, while the arbitration was going on, and even while the section 34 was going on, there are 5 flats which he has constructed for me, but which are still unsold. So in that sense, their claim is entirely secured, and it is secured even today, my lords. So that security is there, my lords, but I need a stay, because otherwise in execution, they are trying to sell off those 5 flats. And on 19th is that matter.
19th execution is kept.
Yes,
My
that
lord,
is kept on 19th.
yeah, I'm led by Mr. Holla in this matter. He's on his legs in court hall number 2. If at all, maybe taken up tomorrow.
Tomorrow.
Or else, please, my lord.
Well,
pass
maybe
to-
have it on the
maybe
9th,
pass
my
to-
lords.
You seek time in the execution. You seek time.
My lord, in that case, my lord, I have one submission to make. The deposit amount may be done in this court, please, my lords, is what my submission is.
But you have
Instead
flats.
of having the flats, my lords, the reason is, my lords, one, the flats value, by the time I got the award and now the value of the award is
Without
differentiated.
hearing, we'll not be able to stand over to
My lord,
8th January.
As well as they will not press the execution.
no, my lords, in that case, let there be a security at least to the extent of my,
Question.
my lords, I have an award in my favor, please, my lords.
Stand over to 13th January. Stand over to 13th January. It was stated that the execution proceedings is pending. Full stop. Either of the parties may seek time in the proceedings, which shall be granted by the executing court in view of the pendency of the petition.
My lords, let there be a security to the extent of the award amount, please, my lords. I had 5 apartments. Let that 5 apartments security may continue, please, my lords. My only request is that, my lords, I have the award. The award stands confirmed. My lords, I have an award.
He said that postpone the execution.
Correct.
My lords, I am absolutely not on the way, my lords. All that I'm saying is the award amount, since the award amount is been confirmed by the
Completely incorrect.
section 34, all that I'm seeking is that, my lords, let that award amount be secured.
It is already
By way of-
secured by the 5 flats.
Let that order also
Today
complete.
we are not hearing. this.
Yes.
No, my lords, because
Please saying that in the executing.
by
proceedings-
virtue of passing of the order in section 34, the security to the extent of the award amount, security towards the award amount was undertaken by them in the section 34. Let that continue here as well is what my humble request is, please, my lord. My lords,
No question
there
of
I would
amount,
not be
right?
even,
Amount can't say.
I would not be have a security also, and no execution as well. My
The
lords. I
matter
have-
is pending, it is to be heard.
Of course, my lords, all that I'm seeking is a security may be extended. Same security what was,
It is given and expiring will be extended.
please, my lords.
Expiring today.
No, it's not expiring.
No, my lords, the reason is once section 34 is completed, it doesn't survive.
They have the keys also and the possession is with them.
No,
He's
no.
the developer. There is a
Possession,
question.
possession
What have
is
I
there.
got to do with it?
My lords, they can always sell it. I mean, I may be having the keys, they can always sell it, please, my lords. They had secured this apartment down below in the court in section 34. Let that security continue is what I'm saying, please, my lords.
If it is continuing, it will continue.
Yes.
Please, my lords, let that order be there. So, my lords, what would happen is if there is no specific order, it would remain as it is that, section 34 is complete, therefore the order merges with the section 34. Since the final order is passed.
Not deciding anything
Yes.
today.
No, my lords,
Something
only on the
adjourned.
security part. I'm nothing else.
Nothing is decided.
Since there is, my lords, all that I'm saying is, since section 34 has come to an end, and there was an undertaking given by them in section 34 that they would be securing the entire award amount, let that continuation of the security happen here as well.
Today it is continuing.
My lords, once 34 is passed,
Today any court has extended it.
no, my lords, by virtue of section 34 coming to an end,
So thereafter this appeal is filed. So in between it is operated.
it is open for them, please, my lords.
The interregnum, what you want is operating.
My lords, today the undertaking given has merged with the final order of the section 34.
Thing
please.
is operating today.
Yes.
So we'll not grant any new order. Whatever is there will continue.
Yes.
That's what, my lords, if that is recorded in your lordship's order,
There will be no execution, that's all. So that the interests are balanced when the appeal is. over.
Absolutely right. my lord.
exactly. my
Both
lords,
sides are
if-
protected.
If
by
my
the
lords,
system.
if my lords that gets recorded, my lords, I would be at least in a security that the apartments which are undertaken in the court below does continue in the appeal as well, please, my lords. Otherwise, my lords, what would happen is in this execution, I'm told not to precipitate, and here, my lords, I will not be having any security as well.
We do not know. If they are ready and it is continuing, then yes. No
My lords,
new- no
it
new
did continue there, my lords. It did continue.
Their interregnum it continued,
Yes, my lords, it did continue. In fact, during the arbitration, I had the security.
the order.
I do have it. Lords, in fact, even in the arbitration, I had it. 9 of the apartments were given to me as a security. In the appeal as well, I had, my lords.
It is not in your appeal. It is their appeal.
Please, my lords. All the time, my lords, I have an award. During the arbitration, I had security.
So we'll consider it that time when we hear the appeal. That's all.
My lords, execution is also getting postponed.
Ah.
I don't have a security. That is the only point
Then proceed with the matter. Nobody says no.
my lords, before the execution court, if the matter is
Yeah,
getting,
you can proceed with the appeal right now.
please, my lords.
Very well, sure. Proceed. Then don't ask for time.
No. My lords, since senior appeared, I also had a brief Mr. Hulla. That is the reason I was asking for my lords. Otherwise, I have no
We
intention.
do not know your internal thing.
No.
Either you proceed or take this. offer.
No, on merits, my lords, because if that is the thing, we can, I mean, I'm ready to also address the court, please, my lords.
Do it. If ready, then
Please, my
proceed.
lord.
Whatever you want, choice is yours. Without wasting further time.
Please, my lords. My lords, this is an
Don't
award.
while away the time.
No, my lords, this is an order.
See that your senior comes. Be straightforward, honest, and transparent before the court.
My lords,
Don't try to while away the time by making irrelevant submissions.
no.
Say what course we are going to adopt, and the order is also passed. If you want to prolong the proceedings
Let's-
in this fashion,
My-
and awaiting that is not permissible.
No,
Mr.
my lords, my only request was that if the award amount is
We
secured, my
understand the
lords,
strategy.
since the execution would get postponed, my only request is that if the award amount is secured,
For the order, anything to be continued, then they will continue it. If any interim order is passed and is continuing in the interregnum between the section 34 decision and filing of the appeal, that will continue.
my lords, in fact, in their appeal, they have not filed the copies of it. I do have it, my lords, but At the moment, I'm not carrying it with me. I do have it, my lords, in 25003, the section 34 appeal which they filed, there was an order of undertaking, please, my lords.
Any such order is operating?
We have surrendered 5 flats.
The order is there. Any order is operating, it will continue.
Yes, madam. Yes, we had
If-
filed an affidavit that 5 flats is secured for the amount, that.
Then why you are worried?
And there you have the possession and also the keys, my lord.
That's what we file an affidavit. Also keys are with them.
Keys are with them.
My lords, page number 821.
They have filed an affidavit that is operating. We can say that whatever arrangement is there, it will continue.
Yes.
Yes, ma'am.
The arrangement prevailing amongst the parties shall continue to remain.
Oblige, please, my lords.
But they will not press for anything further, my lords.
That is already there.
Yes.
Either of the parties
Yes.
shall seek time in the execution proceedings and the executing court shall grant it in view of the pendency of the.
I'm obliged, my lords.
And further, whatever arrangement is prevalent between the parties shall continue to operate till the next date.
Yes, I'm obliged, my lords.
Oblige, please, my lord.
Seal number 42, say review petition, Daniel Kalgi.
Lordship, council is not feeling well. Kindly adjourn the matter. Council is not feeling well.
Council is not there. It was stated that the council, senior council is to argue the case is not, is in indisposed health, stand over to 21st of January, as requested. Next.
Complaints in contempt matters, seal number 43.
The order has
18
been
AM.
complied with, my lords.
My lord, the accused were asked to comply by the order, my lord, on previous dates.
It is complied with or not?
Complied with, my lords. The complied with, compliance has also been placed, my lords.
Yes.
My lord, apologize for the inconvenience. The issue here was pertaining to non-compliance of the order pertaining to the writ petition that was previously filed before the single judge bench, my lord. In that, it was told that we were allowed to approach the chief commissioner of PBMP to file an appeal. And the said appeal was filed on 11/8/2023, my lord, and it was pending for more than 2 years. And that is the reason why we have come before this honorable court contesting a contempt case, my lord. Now that they have placed the document on record, my lord, the instruction is about that the construction has been completed and the complainant where he lives, that said building is being damaged by the illegal construction that has been next to him, my lord. So only what I seek is, my lord, the demolition order may be directed towards the chief commissioner, my lord, so that illegal part of the said construction may be demolished.
You are filing.
Demolition order.
You are for BBM.
Yes. An order has been passed on 30th of October, my lords. We are called for tenders and it will be executed shortly.
Remove the deviated portion.
Yes, my lords.
So they will be removing the deviated portion.
Yes, yes, my lords.
And to report back. So complied.
Indeed, my lord, we were not informed about this compliance report. I just was acknowledging that right now.
While disposing of the writ petition as per order dated 1st August 22, following elections were passed, file on a single judge, paragraph 6 and 7, quote, page 23-24. Today, when the contempt proceedings came up with regard to the above direction, learned advocate Mr. So-and-so produced memo dated 7/11/24, along with which demolition order dated 30th 11/24 2024, issued by the Executive Engineer, Brihat, Bangalore Mahanagar Palika, which contemplate and require the removal of the date portion and to report back in that regard, full stop. Thus, the directions are complied with, full stop. The contempt proceedings are closed. The petitioner shall be intimated once the demolition order is acted upon, which shall be acted upon. Please.
Grateful, my lord.
Once the demolition is acted upon.
Grateful, my lord.
Don't write that it shall be acted.
December 44, so Abhishek Mali Patel.
I appear for his accused number 1 and 2 minutes. The order has been complied. We filed affidavit on 12/9.
Order is complied.
Learned advocate Miss 44. So and so states that the order is complied with. The statement was confirmed by learned of the respondent.
In Patel.
Nothing survives in the contempt proceedings. It is disposed of as not surviving.
Grateful.
Please.
December 45. Mr. Prakash MH.
And for the complainant, your lordship.
Yes.
I just received, yesterday in the evening, I received the counter affidavit from the accused side, your lordship. I may be permitted to file rejoinder. I seek for a time, your lordship. They've just filed counter affidavit along with annexures marking electricity bill, your lordship. In this case, previously, a single bench had passed an interim order not to go along with the construction.
When do you want?
Lordship, a week's time may be granted.
January 22nd, sir, at the request of learned advocate so and so, so and so.
Oblige, your lordship.
December 46. Mr. Shankar Narayan Bhatt.
We have filed a
46.
compliance affidavit.
This may go on 10th in second word. Compliance, right?
My lords, there's substantial compliance, my
We'll
lords.
see on that.
December 47, Mr. Harish HV.
There for the complaint, complaints after Arun. So complaints after to verify and submit, madam. 1 week time, madam.
It is complied with.
Has been complied.
Copy is not issued, madam.
That's all services are done through mail, my lords.
So representation is decided.
Please, my lord, and we have ensured that the senior citizen has
1 week time to verify.
10th at 2:30. 10th in that second board. 2:30.
Number 48.
The complainant in this.
Sridhar Prabhu.
Lord, in this, the submission is, my lord, that last time I had made a submission that, my lord, the endorsement was issued, which was, my lord, to the effect that the physical fitness was, my lord, the issue before the division bench, my lord. The honorable division bench said that the medical test conducted is improper. Then, my lord, a medical board was referred and medical test, my lord, proved that the endorsement given by the KPSC was wrong. And therefore, my lord, I was held eligible for the post. Then, my lord, a contention now is taken after 45 days of filing the contempt. A contention is now taken that yes, the medical you have passed the medical test. Our failing you in the medical test was wrong and you are qualified. But you have secured less marks. Now, my lord, this was urged before this honorable court saying that you have secured less marks. So there's no question of you being considered for the post just because you have physically fit. Now that contention was negatived by this honorable court. A detailed order was passed. And that was, my lord, to say that this contention that I have taken less marks and I was not eligible should have been urged before that very bench, which passed the order holding me eligible for the post. And, my lord, this matter was carried before the Honorable Supreme Court. Honorable Supreme Court, my lord, dismissed the SLP filed by them and confirmed the order passed by this honorable court and, my lord, affirmed that I am eligible on all counts. My respectful submission is, my lord, only now there are about 249 posts. May I, my lord, persuade your lordships to kindly see, my lord, that how many posts are pending at present, my lord. And all that I'm saying is, my lord, let them consider me against any of the posts pending. I'm not, my lord, ready to fight them. I am not even saying whether I'm eligible, ineligible. I have also filed an IA. Based on my order, they have recruited people
May I, my lord, persuade your lordships to kindly see, my lord, how many posts are pending? 249 posts, more than 300 posts are pending. And the motor vehicles inspector post, my lord, most important post, is being kept vacant. May I, my lord, persuade your lordships to kindly see the number of posts, my lord, vacant. Respondent. I am not, my lord, contesting that the
Find out it is possible.
page 5, my lord, may kindly be seen, page 5, my lord. What is the number of? Shall I make my submission? No, I'll just complete, my lord, this submission, just to show before your lordships how many posts are pending and they are, my lord, fighting me up to Supreme Court. Page 5, my lord. What is the number of RTO officers in the state and how many number of inspector of motor vehicles are necessary in so and so, so and so? At present, there are 67 transport officers in the state. 430 are sanctioned posts in the cadre of so and so. Among them, 107 active posts, 323 posts remain vacant. This is given to me under RTI. This is as on 22. All that I am saying is, my lord, there is an order in my favor which says that not conducting the medical, declaring me to be medically unfit is wrong. I should have been considered. Even in 2006, Lord, there is an endorsement issued to the effect. Lord, there is an IA filed on 2510, which is listed before your lordships. Page 11 of that IA, may I, my lord, persuade your lordships to see 2510-24, my lord. This is my last submission, my your lordship. 2510-2024. I was, my lord, the candidate in 2005 notification as well. 2006 notification as well. And it says, my lord, regarding the information requested so and so, public information officer has stated, lordships get it, my lord. Sorry. The commission did not conduct the medical examination for recruitment of motor vehicle inspectors as per notification dated so and so. I was declared that medically unfit when the examination itself was not conducted in 2006. This is how, my lord, I was ousted in 2006. In 2016, I again apply. They say you are medically disqualified. And I approached this honorable KSAT, then this honorable court. This honorable court says, no, that declaration is wrong and holds an order, holds in my favor. Then finally, my lord, they say that you have not secured the requisite marks. Every time I come out with something, once I am medically unfit, but medical examination is not conducted. And again, I am declared medically unfit. Medical examination is not properly conducted. This honorable court sets aside that. Then when I pass that test also, now, my lord, I am told I have not secured the marks. So all that I'm saying is, my lord, I don't want to fight them. I have, my lord, spent 20 odd years in litigation. I have lost my most vital years. 323 posts are vacant. Let them consider against any of the posts under 2006 notification, 2016 notification, and also in the IA, my lord. I have shown that many people are given orders. May I persuade your lordships to see same IA, my lord. There is an order passed at annexure F, my lord. A division bench of this honorable court clearly says that the matter is regarding 2006 notification, the matter is pending before honorable Supreme. Subject to the orders of the Supreme Court, recruit. There is a positive order passed at annexure F, my lord, page 15. That's all I'm saying.
Shall I make the submission, my lord? My lord, firstly, this recruitment is
So is to be considered for the post of motor vehicle inspector.
the apex court passed that order, my lord, related to the 2006 notification, not related to this. And he was a party there. Let him agitate the case before there, my lord, not before my lordships.
No, today, what is the difficulty in complying this?
Difficulty is this, my lord. I will read the direction, my lord. We had complied, my lord. The first respondent, KPSC, is directed to reconsider the claim. This is a 2016 notification, my lord. We are here. And he is, my learned friend is discussing about 2006 notification. We are not responsible for all those things.
Why?
We have considered, my lord. Page number 13, direction
that is
number 4. Sir, one nimsha, please.
Annexure J is the answer to that, my lord. I'm not, my lord, without wasting my lord's time. The same contention was taken. His grievance is endorsement should be given. We have given endorsement. There ends the matter. Annexure J to the IA, my lord, that is before your lordships, considers that in detail and says that this is travesty of justice. This endorsement could not have been issued. Now you cannot come up with a new plea when recruitment is, my lord, ordered. You cannot say that you are medically fit, but marks are not obtained. That is negative. That we have crossed that phase. This case was posted for framing charges, my lord. I am not, my lord, interested in prosecuting them. I have no grouse against them. With folded hands, I am saying
Few minutes.
same contention was raised and negative. Again, my lord, the same contention is being raised. I am reading with your lordships, my lord, page 8 of the IA.
Come on, 11th at 2:30. Let us go through. 11th at 2. Review for reading.
2:30, my lord.
Grateful. 2:30, my lord. Grateful.
In fact, we are.
Could it be 12th? Could it be 12th?
My learned friend is not allowing me to open it. I'm sorry.
50 urgent, number 51 to Bategoda.
He appeared for the complainant in contempt petition. There is a direction to the corporation to execute the sale deed within 3 months. They have not executed. Now, after receipt of the notice in the contempt, they filed writ appeal. 51. Correct. How is that? Contempt. But impugned direction at page 43, para 6. Ink page 43.
43.
Contempt.
43.
43, yes. 43rd page.
40.
Direction in view of the aforesaid
Page,
discussion.
43.
44.3. In view of the above said discussion, writ petition is allowed and impugned resolution so and so by respondent number 1, consequent upon so and so, 2, execute a deed conveying 1 in favor of the petition and his brother within a period of 3 months. They are not in it. We are there in the house since 1947.
Lords, I appear for the accused in 51.1 manner. There's a main matter of writ appeal filed by Mr. Bategoda. He has challenged the same order in the writ appeal, my lords. The single judge's order. So I don't have a copy of that, my lords. So it may be listed after a week or so, my lords.
When the writ appeal is coming,
Lords,
writ appeal is posted, going to be posted when?
it's posted today, my lords. It's tagged, my lords. It is filed by
both-
another advocate, my lords.
Both will take up after some time. 17. 17, next.
17. Bill number 52.
My lord, serial number 52, my lord, I appear for the complainant.
Yes, what do you want?
My lords, if my lords, if this matter can be taken up next week, my lord, arguing counsel had to undertake travel today, my lord. A request for a date next week, if possible, please, my lord.
January 23.
Please, please, my lord.
Bill number 53.
Applied.
The direction they are not
Appear
compliant.
for the accused in this case, my lords. Pray for a week's time, my lords. The
Several number of times.
When you will
has been
conduct the
changed,
matter? When you will conduct the matter?
my lords, the order has been complied.
You have never conducted any matter.
The order has been complied, my lords. The order has been complied.
Give the affidavit, you complain.
I'll be placing tomorrow, my lords, tomorrow.
12th at 2:30. Since it was stated that the order is complied with.
Number 54. Vaishali Hegde.
The case where, my lords, the
That's,
learned-
may I make one submission before the learned senior? That's today there is a meeting, my lords, regarding this. Lordship may grant me about a
Regarding-
week's time, my lords. Today there's a meeting, my lords.
order of the single judge is September 23. After filing contempt, they approached the Supreme Court. Supreme Court has dismissed the SLP.
Today it is a meeting. 12th,
12. Lords, may I request either 13th or 11th? Lords, 12th, I have
13th,
some-
13th,
13.
13th.
please. Lords, 13, 2:30, please.
We'll take 2:30.
This is number 55.
For the complainant, my lord.
Yes.
The order has not been complied, my lords. He has already retired from service on 31st/12/2017, my lords. The pensionary benefits and other arrears of salary has not been released, my lord.
Complied with.
Has not been complied by the BBMP, my lords. This is second round of litigation, my lords. Kindly see page number 24 of this order. my lords.
Notice is.
On
issued.
earlier occasion, my lords, we have filed this contempt petition, my lord.
Notice is issued or not?
London advocate for BBMP undertook, my lord, to comply within 2 weeks, my lord.
Notice is issued or not?
Sanjeev BL.
Wait, he is not there. He is not, the council is not there.
Any short date, my lord.
Short date. Give some date. Yes, next.
Number 56. To GR Mohan.
That's, compliance affidavit is ready, my lords.
Give to council. Learned additional government advocate files compliance affidavit. Copy shall be,
Hello.
so copy shall be given to the council, Mr. GR Mohan for the petitioner stand over to 16th at 2:30.
Number 57. Mr. Vijay Kumar. 57. Vijay
Nothing.
Kumar.
24th January.
My lords. Very good.
Yes, complied with.
No, my lords, this matter is being heard before court hall number 3, my lords, the next day.
Number 58.
That's the order of the
Chennai.
learned judge, single judge is that in March, my lords, March 19, which your lordships would get at page number 9. Annexure A, and the order is at page 13, my lords. Page 13, second and third point, my lords.
My lord.
May I read, my lords?
Who will appear?
My lords, I appear for respondent in this matter. I undertake to file wakalat on the next date, my lords. I seek a request for 2 weeks' time to file my counter affidavit in this.
Let them make some deposit, my lords, it's 7 lakhs odd.
See on that, it is a maintenance.
Please, my lords, for the children, my lords, the education expenses, they have not even paid even 1 rupee.
Lords, the respondent is suffering from spinal disc injury, my lords. The respondent is suffering from spinal disc injury. And
Maybe.
his father is also suffering from kidney failure, my lords, therefore.
From March, my lords, last year.
Please allow me to file counter affidavit on this, my lords.
From March 2023, not paid.
They've not paid even on
23 or 24?
23, my lords. They were supposed to pay by August 19th, my lords. And the trial judge also in page number 49 makes an observation stating that they have opted to not to comply with the direction of High Court. At page 49, if your lordships would get it. Page 49 on 24/8/2024, my lords. The petitioner and counsel called out absent. They were absent, my lords. They don't even appear. They just filed the GNWC. They don't appear,
My
seek for
lords,
visitation.
five appeared
and
and
then
all
they
the
don't-
dates, my lords, in
Am I not-
June. Please, sir.
They file the case, they file an application for visitation. They don't even come and they don't even pay for the children expenses. ma'am.
My lords, I object to this because I am the very counsel who appears on every date, my lords, for the GNWC. And with regards to this, my lords, I request for 2 weeks' time, my lords, to convince the court on this very issue. And also with regards to, I need to, payments. I
File
need
your
to seek in-
wakalatnama and take instructions.
Please, my lords, please allow me 2 weeks' time.
The third quarter fees also should be paid, ma'am.
So 5,71,000 is paid or not?
Nothing, not even 1 rupee is being paid. Not even a rupee.
My lords, I have no instructions on the payment, my lords. Kindly allow at least a week's time for me
When you
to.
will file wakalatnama?
My lords,
When you will file your wakalat patra?
that's what, allow me 2 weeks' time to file my wakalat, or at least 1 week's time, my lord.
When you are going to file? Have you got it?
No, my lords, he is suffering from spinal disc injury and therefore it cannot be, there was no convenient time to be executed. So allow me
When you
a
will
week's
going
time.
to file wakalatnama?
Next week, my lords.
Date?
My lords, next
9,
week,
10, 11,
11,
learned advocate, so and so states. 6 time, not states. To file wakalatnama, which it was stated, which she stated, that will be filed on 11, on or before 11th of December. Send over to 13th December.
Yes,
Take
please.
instruction, then we'll see what to do.
Please, ma'am.
Obliged me.
So number 59, Mr. Ravi Shankar Shastri.
Complainant, my lord. August 2023, my lord, there was a direction to conclude the proceedings within 3 months, my lord.
That's because there's a large extent of land. We have filed an IA before the learned single judge for extension of time, my lords. It is likely to be.
Stated by learned additional government period, indication that an interim application is filed before learned single judge for the purpose of extension of time to comply with the direction.
Please, my lords, to
To-
conduct, to give a Lebanese sketch, my lords, 641 grantees are there. Therefore, we need some time.
Comply with the directions. In that view, send over to 11th February, within which time the appropriate
My lord, already, my lord,
may be obtained from learned single.
already
Please.
15 months over, my lord, till date. My client is a senior citizen, my lord.
Don't say, in that view, the 11th February. If the, we are not mentioning anything, that's all.
In month.
Earlier you want,
Early
Clear.
date, my lord.
20th January.
Please.
This is number 60. Mr. Ranganath S. Joyce, 60. Mr. Ranganath S. Joyce. Bill number 60, Mr. Ranganath Joyce. Bill number 61,
All after, all in January.
Complainant, in 61.
61.
Yes,
My lord, promotion has been granted. That was the direction given. It has been complied with on 7/11/2024 by the first accused.
complied with.
Complied with.
Learned advocate, Mr. So and so, by appearing through video conferencing, stated that the directions which are subject matter of contempt are already complied with. Paragraph. In view of the above statement, nothing survived in the present contempt petition. It is accordingly disposed of.
Please.
Bill number 62, Mr. Sachin B.S. 62.
Here again, writ appeal has been filed.
My lords, I am for the complainant, my lords.
wherein they have not complied the order of the single judge dated 20th day of March 2024, wherein 8 weeks were given for them to comply the directions, my lords. And so that sixth pay commission shall be brought with effect from 1/4/2018, my lords, as per the direction. 8 weeks have passed, my lords. They have not passed any orders. They have not done any.
Who appeared?
My lords, writ appeal has been preferred, my lords, in this matter.
They have not yet filed.
1784 of 24,
They have said they filed 1784 of
writ appeal number.
in view of the filing of writ appeal as stated by learned additional government pleader, against the order in respect of the order which is subject matter of contempt, stand over to 21st January, within which time the respondent appellant shall obtain appropriate orders in the writ appeal.
My lords, they may serve me a copy of writ appeal.
Ask him, they will not. They will serve two. If we write, they will serve only one. Do you want two or one?
Yes.
Give copy to them.
I'll get it.
Number 63, Mr. Satish K.
I'm appealing for complainant, my lord. They have not complied the order. Matter pertains to absorption, my lord.
Lords, in this
Annexure
matter, I
A
pray
is
for
the-
short accommodation, my lords.
My lord, I'm retiring on 31/12/2024, this month, my lord.
This month you retiring.
I'm retiring, my lord.
16.
Sometime 3 weeks, my lords.
He is retiring. I
Retiring.
hope so. Do something. So that you know where he stands, that's all. Before retire. 16th you find.
Pledged.
16th to be listed at 2:30.
Number 64, the ready notice matters. Mr. Subramania Bhattiyam.
Seek 1 week time. 1 week time.
Why?
On the last occasion, on the other side, they have taken appearance for the AG appearance.
What is it about?
Pardon.
It is about what?
It is about to selection of a guested professional, Group A and B post of 1998, 1999 and 2004 batches, my lord. It is a selection made by the KPSC. It is a old matter, so I humbly request that it may be taken on priority, my lord.
When will come? 17th?
Yeah.
17th December.
Much obliged.
Number 65. Study 65.
My lords, I'm appearing for the petition, my lords.
So I am for the fourth respondent. I am for the fourth respondent in this matter. My statement of objection is ready. I will file during the course. I'm not able to serve the copy on the petitioner counsel. Kindly grant me next week.
Sorry, my lords, I could not appear before the court, my lords. I'll collect a copy, my lords.
22nd January.
Please.
Please, my lords.
So list number 3 for pronouncement of. Cell number 1, writ petition. Writ petition 15147 of 2022. Say Muralidhar Rao, 14%.
15147 of 22. Petition is dismissed.
Bill number 2, contempt 224 of 2023, Mr. Arun BM.
They appear for the complainants, my lords.
Yes.
Contempt 224 of 23. In the light of the above aspect, it is held that endorsement dated 28/6/22 marks substantial compliance of the directions in WP 4662 of 2017 dated 15/1/21. Nothing survives for consideration in this contempt petition, accordingly dismissed.
Bill number 3, writ appeal 257 of 2024.
Writ appeal 257 of 24. The court finds no legal infirmity in the order passed by the learned single judge that there is no justification for interference. Accordingly, appeal is dismissed.
CC number 4, contempt 1168 of 2023.
Contempt 1168 of 23. This court in the aforesaid factual aspects holds that the directions are substantially complied with and nothing survives for further consideration in this contempt petition. Having regard to the decision of the board dated 18/6/24 marking compliance with the directions, the issue regarding the applicability of section 20 of the act renders academic. In the light of the above discussion, the contempt petition is disposed of.
Extremely sorry, it is my
Then
fault.
day after.
But from tomorrow for 1 week, I'm out of the country for some medical help.
Tomorrow may not be.
Can it be anytime thereafter, 16th or 22nd January?
16th January.
16th January, can I request for 2:30?
16th January.
That CL number 130.
I'm very sorry, my lord.
No problem.
I was
Serial number-
imparted 2:30, my lord.
Serial number
Grateful to your lordship.
130.
In order to continue.
Interim order shall continue.
That serial number 131.
Serial 71, court of. It's the.
Serial number 131, my lord. The urgency the matter, my lord. From 22nd November, my lord, today posted. But the urgency in the matter, the KDB officials, my lord, every day, my lord, trying to, coming to the land, my lord, saying that, my lord, vacate the.
What is the urgency?
My lord, urgency is, my lord, sought for interim order, my lord, the.
That is right, but what is the urgency for interim?
The
order?
urgency, my lord, KDB has acquired, my lord, only 12 guntas. In that, my lord, I have constructed house since 20 years back.
Date of disposition, residential.
130.
17th.
Some-
17th. 17th.
Serial number 119, your lordship, is kindly posted this week, your lordship, it has come.
You mentioned it.
Yes. in the
What is it about?
Pardon, your lordship?
It is about what?
It's a contempt petition, your lordship.
Like,
There is a direction to register.
Which one?
Who will appear on your?
One nine.
I appear by.
There is a direction, your lordship, in July itself, but it was not complied.
This notice has not been issued in this matter.
Notice is not issued.
No. The office objections.
They were supposed to comply within 30 days of time, your lordship.
Notice written, heard, learned, and so and so and so, notice written on 9th January.
My lords.
Office of this shall be removed for the next day.
Serial number is 89, 1257, PC. Office complete, they were not complete the office. They were not complete the office complete.
Come near mic.
Serial number 89, they were not completion the office complaint. Their office objection is already given to 1257. Kindly direction to the, they were office complaint.
This complaint, they are complied with.
They were not completion the office complaint.
Complied with? Learned advocate, Mr. So and so states that all officers are complied with. The office. Complied with or not complied?
Not complied.
Then comply with.
They were already taken 2 weeks time.
Learned, 3 further weeks are granted to comply with the office.
Thanks.
My lord, in serial number 96, my lord. In serial number 96, my lord. Lokayukta has filed a report, my lord, in that they held the parties, my lord, but the address is not available, my lord. They are the government parties, my lord. Kindly direct the government to take notice.
Serial number 104, my lords, transmission matter, my lords. Serial number 104, moved on the liberty given by the Supreme Court, my lords, any day convenient to your lordship.
104.
When 104, my lords.
Is there? 104 is what? Appeal.
My lord, Supreme Court, we had sought the liberty to move my lordships for clarification, modification, my lord.
Oh.
I have the Supreme Court order.
At,
Any day when it reaches. subject to
television
the
channel.
My lord's transmission of the TV channel.
TV,
We are the beneficiary of my lordship's order.
17.
17, my lords. 230 if my lords.
17 2.
My lord, serial number 75. My lord, serial number 75, my lord. It's a doctor's matter, radiology department. The doctors have not been permitted to practice more than in one district. This matter has been pending for a very long. So kindly any date may be, my lord. Short date.
21st February.
My lord, in January.